sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good afternoon, Osceola County. Can you hear me okay?
Yes, sir.
All right. Thank you. And Mr. Assistant Public Defender, your name for the record, please?
Edward Lopez on behalf of the Public Defender's Office.
Thanks, Mr. Lopez. And we have Ms. Morales here with me in court.
Yes, Your Honor. Maria Morales on behalf of the state.
Thanks. And who do we have for pretrial release?
Jonathan Marino.
Good afternoon, Mr. Moreno.
How you doing?
Well, thanks. Okay, good afternoon, everyone. We're here for initial appearance. As you heard from that little video, initial appearance is really just for three things. The first thing is for me to take a look at the charging affidavit and make a determination as to whether there is probable cause for your arrest that's already happened. After I make that determination, we're going to talk about getting an attorney on board for you if you qualify for the services of a state-appointed attorney. After that discussion, we're going to talk about conditions of bond if you qualify for a bond. That will get you back to your lives while these cases are pending. I'm going to take well, before I get there, I know some of you may disagree with what's in the charging affidavit. I totally get that. I understand that you may have a disagreement as to the facts of the allegations against you. Today is not a day for that discussion. It's unlikely I'm your trial judge. You should save that discussion for an attorney if you choose one, or one is appointed for you and your trial judge. We're going to take our interpreter cases first.
Hello, Cisco Unity Connection Messaging System.
All right, we're going to take the interpreter cases here in a little bit. It doesn't seem like we have an available interpreter. First case that I have is Isaiah Castillo.
President approaching, Your Honor.
Thanks. Good afternoon, Mr. Castillo.
How you doing?
Mr. Castillo, you were arrested based on an out-of-county warrant. That warrant is out of Hillsborough County. It alleges an allegation of carjacking firearm. That's a first-degree felony allegation punishable by life. Hillsborough County, for whatever reason, has decided to grant you a bond in that case in the amount of $15,000. And so you are bondable. Thanks. State of Florida versus William Brine.
This time we'll be waiving his appearance. He refused.
All right, Mr. Brine failed to appear for pretrial in front of me. I didn't have any additional information, so I issued a warrant for his arrest. Finding his failure to appear was willful, I issued no bond on his cases. He'll remain on no bond until he wants to come explain to me what's going on. And I believe the Office of the Public Defender was already appointed on that case. Thank you.
And Your Honor, I believe he had two cases. So
He did. Yeah, that's on both cases. He had cases 2021 CF 2707 and 2021 CF 2639.
Noted. Thank you, Your Honor.
Thanks. State of Florida versus Michael Chaser.
time, we'd be requesting a waiver of reading of his charges.
No problem. Good afternoon, Mr. Chaser.
Hello.
Mr. Chaser, you are here with us based on an allegation that you violated probation in 2016 CF 3855. It's a violation of rule number 5. Your attorney has let me know that you are aware of the details of that allegation. You were arrested by warrant. Judge Nix Walker issued no bond. You're going to stay on no bond until you can get in front of her and let her know what's going on. And I will appoint the Office of the Public Defender if they were not previously appointed.
Okay. Thank you.
Thanks.
Thank you, Your Honor.
State of Florida versus Sean Fleck.
Your Honor, we'd be waiving Mr. Fleck's appearance. He did refuse as well.
All right, Mr. Fleck has refused every single court appearance with me since he was initially arrested. I'm going to reset Mr. Fleck. I'm going to have the jail bring him by any means necessary. They can put him in the cage. I want to see Mr. Fleck tomorrow.
Yes, Your Honor.
State of Florida versus Gonzalez Brioche, or Broche.
President approaching, Your Honor. He's in the cage. Give us 1 second.
Thanks. Good afternoon, Mr. Gonzalez.
How you doing?
I'm well, thank you for asking. Mr. Gonzalez, you were with us based on a warrant that Judge Epperson signed for you. It alleges that you failed to appear for arraignment. He issued a bond in your case. Your bond is set in the amount of $250, and I will appoint the Office of the Public Defender.
Yes, Your Honor.
Thanks. State of Florida versus Willie Griffin. Good afternoon, Mr. Griffin.
Yes, sir. Good afternoon, sir.
Mr. Griffin, you were arrested based on an allegation that you violated your probation. The case number is 2017 CF 3943. Based on the information in the affidavit, Judge Young issued a warrant for you with no bond. You're going to remain on no bond until you can get in front of him. Your attorneys can get you there over there and let him know what's going on. I'll appoint the Office of the Public Defender if not previously appointed.
Yes, sir.
Thanks. State of Florida versus Jock Teague.
Approaching, Your Honor.
Thanks. Good afternoon, Mr. Teague. Mr. Teague, you were arrested based on an allegation that you violated probation in 2021 CF 1674. Based on that information, I issued a warrant for you. It alleged that you were no longer, I'm sorry. Yeah, you were unsuccessful. The allegation is that you were unsuccessfully discharged from the Phoenix house. Based on that information, I issued a warrant with no bond. You're going to remain on no bond until your attorney can come out and talk to you and let me know what's going on. And I'll appoint the Office of the Public Defender to represent your interest. Thanks. State of Florida versus William Threet.
President approaching, Your Honor.
Good afternoon, Mr. Threet.
Good afternoon.
Mr. Threet, you were arrested based on a warrant from Judge Sanders Morency. The allegation was that you failed to appear for a status hearing. Judge Sanders Morency issued no bond. You're going to remain on no bond. She was in the best possible position to establish a bond when she set the warrant, so you're going to have to explain things to her. Are you represented by the Office of the Public Defender?
Yes, sir.
All right. They'll know how to get you in front of Judge Sanders Morency pretty quick, and that will conclude our initial appearance today. Thanks. State of Florida versus Janie Bingham.
She's in the cage, Your Honor. She's coming up in 1 second.
No problem. Officer Moreno, does Ms. Bingham now qualify for PTR, or is she still not qualify?
Your Honor, let me check real quick just to make sure she got removed out of the current medical status.
Sure, thanks. Good afternoon, Ms. Bingham.
Good afternoon.
Ms. Bingham, you were arrested based on an allegation of battery on a law enforcement officer. I read the charging affidavit. I do find probable cause for your arrest. Court is going to appoint the Office of the Public Defender to represent your interests. I'm going to set bond in your case. It's going to be an alternative bond. Bond will be set in the amount of $2,500 if you do not qualify for pretrial release. If you do qualify for pretrial release, your bond is going to be set in the amount of $1,000 with pretrial release with the following conditions: that you do not possess or use any illegal substances, and you'll be randomly tested for any drugs in your system.
Your Honor, we just checked. At this time, she doesn't qualify for PTR.
Okay.
So we would be unable to do the drug testing.
All right, Ms. Bingham, your bond is set in the amount of $2,500 with the condition of your bond that you are not to possess or consume any illegal substances. Thank you. State of Florida versus Alfonso Castro. Good afternoon, Mr. Castro.
Good afternoon, Your Honor.
Mr. Castro, you were arrested with us. The allegations are trafficking in methamphetamine, altering, destroying, concealing physical evidence, and possession of drug paraphernalia. I've read the charging affidavit. I do find a factual basis, or sorry, probable cause for which the court, for which you have been arrested. Bond in this case is going to be set in count one, the amount of $250,000 is to count two, and the amount of $1,000 is to count three, and the amount of $250. I notice that you're out on bond already on 2020 CF 12745-0. That's out of Orange County. The court has probable cause to believe you have committed a new law offense. While you're out on bond, your bond on that case is revoked and is set at none. Thanks. I'll appoint the Office of the Public Defender on our new case. State of Florida versus Julia Clemente. Good afternoon, Ms. Clemente.
Good afternoon, Your Honor.
Ms. Clemente, you were arrested based on an allegation of battery domestic violence related. That's a first-degree misdemeanor. I have read the charging affidavit. I do find probable cause for your arrest. I'm going to appoint the Office of the Public Defender to represent your interests while you're here with us. I'm going to consider conditions of bond. You do qualify for a $500 bond with pretrial release conditions. Mr. Lopez, do you want a minute to ask Ms. Clemente whether she's here on vacation?
Honor, she is here on vacation. She's from Maryland.
All right. Did she fly or drive down here?
She flew, Your Honor.
All right. I don't have any information from Mr. Hunt. I'm not exactly sure what the contact provision should be.
We attempted to make contact with the victim. The phone number was disconnected. And for the record, she has no prior history.
All right. Without any information from Mr. Hunt, it's going to be no contact as a condition of the bond. They're meant to maintain separate residences while this case is pending. I'm sure that Mr. Lopez, do you want to ask if she still has some personal belongings at the Gaylord Palms?
Your Honor, she still does have her property at the hotel room.
All right. I suspect she probably trespassed from there, but the court will allow her to return one time with law enforcement to get her personal belongings.
Thank you, Your Honor.
Thanks. State of Florida versus Jason Chandler. Good afternoon, Mr. Chandler.
Good afternoon, Your Honor.
I saw you yesterday, right?
Yes, Your Honor.
All right. This allegation alleges something that happened in the jail. It's criminal mischief of $1,000 or more. I took a look at the charging affidavit. I do find probable cause for your initial arrest and added charge. I'll set a bond in this case in the amount of $1,000 and appoint the Office of the Public Defender to represent your interests. Thanks. State of Florida versus Nathaniel Reed.
President approaching, Your Honor. Give us 1
Thanks.
second. He's in the cage.
Good afternoon, Mr. Reed.
Good afternoon.
Mr. Reed, you were arrested based on allegations of possessing cocaine and possessing drug paraphernalia. I took a look at the charging affidavit. I do find probable cause. Court's going to set bond in your case. Well, let me ask PTR. Does he qualify for PTR?
No, Your Honor, he's still on a psychiatric evaluation.
Okay. All right, Mr. Reed, $1,000 bond on count 1, $500 as to count 2, and I'll appoint the Office of the Public Defender. Thanks.
Good afternoon, Your Honor. Jaime Sotomayor, certified federal interpreter, already sworn.
Good afternoon, Mr. Sotomayor. We have 3 folks that need your assistance. You'll be doing the interpreting over the intercom system.
Yes, sir.
First case that I have is Daniel Castro Cabrera. The case number it's a Polk County case number, and I'm afraid I don't. I've got CF 1829896, Mr. Interpreter.
286.
Yep. Good afternoon, Mr. Castro Cabrera.
Hi, how are you?
I'm well. Our interpreter is going to interpret for me, and then you can speak to him in Spanish, and he'll interpret it back into English, okay? Mr. Interpreter?
Yo lo voy a estar traduciendo al español. El juez le va a hablar en inglés y entonces usted contesta en español y yo le traduzco al juez en inglés.
Ok, gracias.
Very well, thank you.
Sir, you were arrested based on an out-of-county warrant.
Usted está arrestado por una orden de arresto de fuera de este condado.
The warrant alleges a violation of probation for a petty theft case.
Esa orden alega que hubo una violación de la libertad supervisada probatoria por un caso de hurto menor.
The warrant issues no bond.
La orden de arresto no tiene fianza.
You're going to remain on no bond. We will let Polk County know that you are here with us.
Usted va a permanecer sin fianza y va a permanecer aquí en este condado hasta que lo recojan de Polk County.
You should be transported over there pretty quick.
Y lo deben transportar para allá bastante rápido.
Thank you, sir.
Gracias, eso es todo.
Gracias.
Thank you.
State of Florida versus Nestor Filet. Mr. Interpreter, this case number is 2012 DR 807.
Thank you.
Good afternoon, sir.
Buenas tardes, señor.
Buenas tardes.
Good afternoon.
Sir, you were arrested based on a writ of bodily attachment for a unpaid child support amount.
Usted está arrestado debido a una orden de detención por una deuda de pensión alimentaria.
Your bond amount apparently is what you owe.
Aparentemente la fianza es la cantidad que usted debe.
That purge amount is $3,340.
Esa cantidad es $3,340.
Thank you.
Gracias, eso es todo.
State of Florida versus Fanny del Socorro Menura de Calle.
Good afternoon.
Good afternoon, ma'am.
Buenas tardes, señora.
The case number, Mr. Interpreter, is 2015 CT 2076.
Thank you.
Ma'am, you were arrested based on a very old bench warrant that was signed by Judge Draper.
Usted está arrestada debido a una orden de arresto muy antigua que firmó la juez Draper.
The allegations are that you failed to appear for a violation of probation arraignment on that case.
La alegación es que usted no compareció al tribunal para una lectura de cargo por una violación de la libertad supervisada probatoria en ese caso.
I'm going to ask the state regarding this particular defendant's criminal history.
Le voy a preguntar a la fiscalía sobre el historial criminal de esta acusada en particular.
Yes, Your Honor, just a moment. I'm looking it up. That case is actually not in our system.
Sí, su señoría, lo estoy buscando porque el caso no me aparece en el sistema.
Your Honor, for the court's knowledge, Miss Munera de la Calle has various health implications. She takes medication for stroke. She takes medication for various health illnesses that she has.
Su señoría, para que usted tenga conocimiento, la señora Munera de la Calle tiene varias condiciones de salud. Ella está tomando medicamentos por un derrame, está tomando medicamentos por distintas condiciones que tiene.
Your Honor, I just want to let you know, I was able to locate her Florida criminal history. This is the only case that she has. It's no valid.
Sí, su señoría, quería informarle entonces que hemos verificado los expedientes. Ella tiene un solo caso que es por manejar sin licencia válida. Este es el único caso.
I'm going to appoint the Office of the Public Defender to represent Mr. Munera de Calle.
Muy bien, señora Munera de Calle. Le estoy nombrando a la oficina del defensor público para que la represente.
Mr. Lopez, will you verify that the Foxhall Circle address is her current residence?
Le voy a pedir al licenciado López que verifique si la dirección está correcta, la de Foxhall.
Yes, Your Honor, one moment.
Un momento.
May 19th. Next Thursday.
Where?
That is her correct address, Your Honor.
Sí, esa es la dirección correcta.
Court is going to set a bond in this case in the amount of $100.
El tribunal va a imponer entonces una fianza en este caso por la cantidad de $100.
Let me ask whether she was evaluated for pretrial release. She may not have been based on the warrant.
Y voy a preguntar si fue evaluada para libertad anterior a juicio porque basado en esta orden quizá no fue evaluada.
No, Your Honor, she was evaluated because typically we don't interview people who are here for BOPs or FTAs.
Okay.
No fue evaluada porque usualmente no evaluamos personas y no entrevistamos personas para violaciones de libertad supervisada probatoria.
I think posting the bond will probably be the quickest way out. I want to advise her she has a hearing coming up on the 19th of May.
Yo creo que entonces la forma más rápida de que ella pueda salir a la calle es cediéndole la fianza, pero le debo informar que tiene una vista en el tribunal el 19 de mayo.
Okay. Thank you, George.
Yes, ma'am. So you should have notice of the hearing on May 19th in front of Judge Sanders Morency.
Entonces usted debe recibir por correo una notificación de esa audiencia que tiene el 19 de mayo con la juez Sanders Morency.
Okay.
Do you know where to be and when?
¿Usted sabe dónde tiene que ir y cuándo?
Aquí en Kissimmee, aquí mismo.
That's here in Kissimmee, right?
Yeah.
That's correct. That's at our courthouse.
Sí, en el tribunal, en el edificio de la corte.
Your Honor, at what time is that? It's on 5/19 at what time?
8:05.
Es a las 8:05 de la mañana el día 19.
Courtroom 4A.
La sala es la 4A.
Thank you, Your Honor.
All right. So you do have a bond now. Please don't miss your court hearing. I'd hate to see you get arrested again.
Y entonces ahora usted tiene fianza. Por favor, no falte a la audiencia en el tribunal porque no me gustaría que la vuelvan a arrestar.
Thank you, George. Thank you so much.
Mr. Sotomayor, I believe that's the last of the help that we need. Thank you.
You're welcome, Your Honor. Have a good day.
Thank you.
Thank
Lopez, that's all we have today. Any additional clients?
Not at this time, Your Honor.
All right, thank you. Corrections, do you need something in writing from me regarding Mr. Fleck for tomorrow?
One second, Your Honor.
Thanks.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Okay, I just started the live stream, so we're now in a public session. I've set up several breakout rooms so that if the parties would like to discuss their matters before the trial, hopefully reaching a resolution, I will allow you that time. It's not something that is required, but is something that I believe is potentially beneficial to resolve matters rather than place it in my hands, because I will make a decision, and the decision that I make is going to be the decision that carries the case. The person that has the iPhone, it looks like you're in your car driving.
Yes.
What's your name, ma'am?
I'm Cheryl Bridgewater with Hunter Ridge. I'm almost to the office.
Okay. I would, because you're technically breaking the law, and as a judge, I can't sit and allow you to do that. So pay attention to where you're going.
Okay.
And I will.
I'll log that in like 3 minutes.
Okay.
All right.
That's fine. It looks like that the plaintiffs are here.
Okay.
So that may be something that when you get to where you are, that you and the plaintiff can be in a breakout room.
Okay.
But there's, I mean, I won't say it's unfortunate, but judges have been cautioned about the whole distracted driving law and Zoom call situation. So I just needed to bring that to your attention.
Okay, no problem. I'll log back in like in about 3 minutes.
Okay. So I'm gonna start calling the calendar. And when you hear your case call, please give the appropriate announcement. Position 1 is Maurice Downey.
Yes, sir, I'm here.
Okay. Mr.
Right here.
Okay, I see you. Mr. Downey versus S&J Truck Repair. Is there anyone here from S&J Truck Repair? It looks like there's a Joseph Todd that is listed as counsel. Okay. Now I'll come back to you, Mr. Downey. Position 2, LVNV Funding versus Rodney Bell.
Skip reading for the plaintiff, Your Honor.
Okay. And is there anyone here on behalf of Rodney Bell? Okay. Position 3, Hawthorne 1 HOA versus Merle Solomon.
Yes, I'm here.
Daniel Green for plaintiff, judge.
Okay. And your name, ma'am?
It's Merle J. Solomon.
Okay. And do you believe it would be beneficial to have a conference with Mr. Green prior to proceeding with the trial?
Yes, if you can work some discounts out with me. Yeah.
Your Honor, I don't think I'm going to be able to do that. So I think that's kind of part of the issue.
Okay.
I certainly don't mind speaking to her, though.
Okay. And just so you know, Ms. Solomon, as a judge, I don't get involved in negotiations as it relates to resolving a matter.
Okay.
So I'm going to allow you and Mr. Green to speak. And if you can't reach an agreement, then it'll come back to me. But in the same manner, I'm not here as a person to kind of force a resolution anyway, either for or against either party.
Okay. Well, if I talk to him, the court fee, will it be taken off or no?
That's something that you will have to speak to him about. If it's through negotiation, if it comes to a trial and I rule against you, then the court fee will be included within that. Okay.
That's fine. I'll talk to him.
Okay. Position number 4, Richard Moore versus Hastings Enterprises.
Yes, I'm Jeffrey Ellis with the owner of Hastings Enterprises.
Tell me your name again, sir.
Jeffrey Ellis, E-L-L-I-S.
Okay. Is Richard Moore present? Okay. Well, I'll come back to you, Mr. Ellis. There may be issues that you're going to have to decide upon.
Okay.
Position 5, TD Bank USA versus Francis Riggy. Is anyone here from TD Bank? Is anyone here from Francis Riggy?
Judge, sorry, Daniel Green for plaintiff.
Okay. There's a lawyer listed as Jamal Williams on Francis Riggy.
Yes, Judge, I think if we could continue that case I think we're in the midst of settling that one. So we're just requesting a continuance.
Okay. I will get you the date, but I'll continue it back to my calendar. So it should be 30 days.
Thank you.
Okay. Position number 6, we have Shantina and Jeremy Carson versus Hunters Ridge Mobile Home.
We're here.
And Miss.
I'm here. And my husband is here. Say something, Jay.
Yes, I saw both of you. And it looks like you told me the name, but I didn't write it down. But it looks like the attorney is back, or the person who's representing Hunter Ridge Mobile Home. Can you tell me your name again, ma'am? I'm sorry.
Oh, I'm Sherilyn Bridgewater. I'm the property manager. Richard Taylor is the attorney.
It's a whole other staff. Look like it.
Mr. and Mrs. Carson, everything you say is heard by everybody, and it's going out. Hold on, and it's going out on the internet. So I would advise you to use your words carefully. Okay. Thank you. And you're the property manager, and you said there is an attorney, but I don't have an attorney listed.
Richard Taylor, he's actually the one that notified me this morning. That's why I was on in the car.
Okay.
I can give him a call.
No, I've dealt with Mr. Taylor. All right, so I'm going to hold for Mr. Taylor to report. Finally, we have Michelle Woodby versus Rona Johnson.
Michelle Woodby, present.
Okay. Is Rona Johnson or Abdullah Bubakar present?
Yes. Yes, we're here.
Can you identify yourself, ma'am? It says Rona Adio.
It's Rona Adiri. I'm the parent of Abdullah Bubakar.
Okay. Do you believe, ma'am, it'll be beneficial to have a conversation with Ms. Woodby as it relates to trying to resolve this dispute before we have a trial?
We can proceed with the trial because my son didn't commit that act.
Well, that's for me to decide. You do understand that, correct? Hold on, Ms. Woodby.
Oh no, I was speaking to my witness, my neighbor. That was it. No, but I agree. There's no need for us to have a mediation. We can speak right directly to you.
Okay, so there are going to be some issues that are involved as it relates to a Zoom situation. There's a concept in the law called the root of sequestration, which means a witness doesn't get to sit and hear all the testimony and then opine or add or detract from the testimony that they give. So if you have a witness, that witness cannot be in earshot of anything that is being testified to.
So does she need to leave? Because it states at the bottom, it states if she was not voluntary, but she's voluntarily coming to, it states that I needed to submit documents if she wasn't, but she's voluntarily coming over to state what she witnessed. So does she need to leave?
Okay, so can you restate to me what I said to you?
No.
Okay, I'm going to explain it to you again, and I want you to listen, okay? The rule of sequestration states that a witness cannot be in earshot of whatever is being testified to.
Okay. So I'll call you when they ask for the witness. So yeah, you'll have to leave and then I'll call you. I'll text you to come back when he asks for the witness. Yes, sir. I understood.
Okay. All right. This is going to be the last hearing. This between Woodby and Johnson and Bubakar is going to be the last hearing. So I already see it's going to be some issues I'm going to have to work out and deal with between the two of you. So I'm not going to hold everybody up while we're dealing with those issues, okay? All right, so I'm going to place Mr. Green And Miss Solomon in breakout room 1. It's Bridgewater. You said you were trying to reach Mr. Taylor. I think you're still on mute. Mr. Breeden, which case are you here on?
I am here on the Rodney Bell case, Your Honor. LBNB funding versus Rodney Bell.
And Mr. Bell didn't appear. Let's see.
And his answer also admits the claim. So.
Yeah. Okay, so it looks like there's only going to be one breakout room, and that's going to be between Mr. Green and Miss Solomon. So I am going to assign the two of you to that breakout room now. Well, before I do that, Mr. Green, let me address the issue with Mr. I believe it's Mr. Downey. You're in the magistrate courtroom also.
Yes, sir.
Well, no, I'm sorry. You're at home.
Yes, sir.
The gentleman next to Miss Solomon. Will you tell me your name again, sir?
Okay.
Jeffrey Ellis with Hastings Enterprises.
Okay. Mr. Ellis, the plaintiff has not appeared. Your case is going to be dismissed for warrant of prosecution. So you are going to be able to leave.
All right. Thank you. Have a good day. Thank you.
You too. So I'm going to place Miss Solomon and Mr. Green in the same room. I'm sorry. My list is not popping up. Okay, Miss Solomon, you're in breakout room 1. You should be able to see a link, an option to click on the link.
Okay.
Okay. If you click on that, that'll allow you and Mr. Green. There you go. The top. Mr. Breeden,
Yes, Your Honor.
This is a situation where there's the defendant has not appeared. So I want you to present your evidence as it relates to what you believe should be afforded to your client.
Sure, Your Honor. Well, I officially will move to strike his answer and enter default judgment. The damages on this case are liquidated. It's a credit card case. We're seeking principal of $909.25. That amount, statement for that amount was attached to the complaint. In addition to that, we are seeking court costs in the amount of $100.
So you're seeking a total judgment of $1,995.
$1,009.25.
$9.25. Okay, so the request for the motion to strike, the answer will be granted, and you'll have a money judgment in that amount. I'm just going to need you to send me a proposed order and I'll sign it.
I'd be happy to do so, Your Honor. Do you want that submitted e-filed, or do you want me to email it someplace?
Email it to Mary.Moultrie, MOULTRIE at Clayton County, Georgia, ClaytonCountyGA.gov. She's my judicial assistant, and you can send that to me and we'll get it taken care of.
I appreciate it, Your Honor. May I be excused?
Yes, sir. Have a good day.
You too.
Mr. Downey.
Yes, sir.
The defendant has not appeared here today. So what are you requesting?
I'm requesting 15 grand for the 9 grand I gave him 9. Let me get my own paperwork to his receipts, because you have it too. I gave him $9,470.08 for repairs. And long story short, my heads needed fixed on my truck. My mechanic wasn't available. But my mechanic diagnosed it, said my heads was blown. I needed my truck fixed right away. I went on the internet looking for a diesel mechanic near me. Mr. Steve, I called him. We talked about 30 minutes. He sounded like he knew what he was doing. I took my truck to him on July 10th for him to diagnose the truck. He called me on the 16th, told me the truck was ready. Told me the truck, the price went up by $2,300 and change. Told me it wasn't my head. Told me it was my fuel cup. I never heard of fuel cups, but he's a mechanic. So I took his word on it. I paid him. The next day, which was Friday, the 17th, I picked up my truck, took it to pick up a load, and I went about 25 miles. All my cooling was going out the truck. I called him back. I said, I have to finish this load. I had to go to Texas and come back, but I need to bring my truck back so we could discuss why my truck is still losing cooling after I gave you $2,300 and change. And he said, bring it back. He said he gonna, oh my God. Hello? Oh man. Baby, the video gone.
Judge, since we got a little break here, I've settled the case with Mrs. Solomon, the Hawthorne HOA case.
Okay.
We'll be mailing her a consent. If we could just get a continuance, we'll get that hopefully in the mail, and file it with the court.
Oh, okay. Send it to the agreement. We'll do a 30-day continuance on this.
Hello,
case.
Your Honor.
Hold
I'm
on,
sorry.
hold on.
Oh, I can't see.
We'll do
I'm
a
sorry.
30-day continuance, and I'll send it. If you send it to me, I can't see you, Mr. Green. I can see your phone.
I'm sorry, I'm here. Sorry about that.
So if you could just send the documentation to Mary.Moultrie at Clayton County GA.gov, we can get it resolved.
Thank you, Judge. May I be excused?
Yes, sir.
Have a good day.
You too. And Miss Solomon, I don't think she came back on.
I think she's out. Thank you.
Yes, sir. All right, Mr. Downey.
Yes,
you
sir.
Said you paid $2,000.
$2,300 the first time, and he said he misdiagnosed it. He said the price of fixing it was gonna be $5,000. He said, but he gonna subtract the 23, which I got all the text messages I gave him to you. And I just have to pay 24. So on top of that, when he called me on August 28th, he told me my truck was ready. This is from July 10th, August 28th, he told me my truck ready, that it's gonna cost me an additional $5,000 on top of the 2,300 I gave him. So then I gave him that. I had to take out a title loan because I had to pay my mortgage. I had to pay everything because he took so long fixing my truck. I had to take a title loan out. I got my truck on August the 1st. On the 4th, it was broke down. And I text, I got all the text. If you want to go to the text, I got them numbered.
Mr. Downey, I want to hear your testimony.
Yes. Okay. Mr. Steve, I took my truck to Mr. Steve J truck repair, and he didn't. I gave him all that money. He did not fix my truck. I had took it to another mechanic that fixed it and paid them $10,000 to fix what Mr. Steve supposed to have fixed. I lost 2 contracts.
Mr. Downey,
yes.
So far all you've established is that you're out of $9,470.80.
Right. So you want to hear?
This is Mr. Downey, they call it a windfall. This is not a situation where you were done wrong and you're entitled to a windfall because you were done wrong. You're entitled to be restored back to being whole.
Yes, sir.
Meaning at the point that you were the day before this happened.
Right.
Okay. So I don't need to hear, as I would say, the whole of the Oprah show. Or we'll say whatever these daytime people
right
be on TV. So you're entitled to the damages and the court costs, which at this point appears to be $9,470.80.
Yes, sir.
And $100 court costs.
Yes, sir.
Okay.
Okay.
All right. That will be the order of the court. Is there anything else, Mr. Downey?
Do I go down to the courthouse and get the paperwork, or are you gonna email me, or?
It's gonna come to you in roughly about 10 days.
Yes, sir. Thank you.
But that's just a piece. It's going to be a piece of paper saying that you're owed that. You're going to have to do what you need to do and post judgment to try to collect on any monies that are owed.
Okay.
Okay.
Okay, thank you.
You're welcome. Have
Will
a
I
good
be
day.
dismissed?
Yes, sir.
Okay, thank you.
You're welcome. Okay, let's turn to Ms. Carson versus Bridgewater. I'm sorry, versus Hunter Ridge Mobile Homes. Ms. Bridgewater, were you able to reach Mr. Downey? I mean, sorry, Miss Taylor, sorry. You're still muted. You're still muted, ma'am.
Sorry about that. Yes, I did reach him. He was contacting me for a Shatina handbrake. And I said, no, this is the Shatina Carson. So he said it had been pushed back to 1:30. So I don't know if these are the same people, two different last names or what.
My name is Shantina Carson, not
Carson?
That's
Okay. So it's two different people. I'm not even sure if I've even met Miss Carson before.
Nah, it was a whole, that's what I was saying at the beginning. I think it's a different staff at the time. You guys are not the same staff it was when we were living there.
Oh, okay. Because I was like totally confused. I'm like, I don't know this person. Okay.
Yes, ma'am. When we left, we have our actual move out letter that said we was owed a deposit, so we didn't know what was going on. But I know we still had to report today, so I'm not for sure what's going on.
Okay. Can you guys see me? Because I can't see anyone. I didn't know.
Yeah, we can see you. We can see everybody.
Mr. and Mrs. Carson, I need you to turn your camera on.
Okay.
Okay. So what I'm going to do is place the two of you in a breakout room.
Okay.
Miss Bridgewater, Miss Carson, and Miss Bridgewater, I'm going to ask you to contact Mr. Taylor so that you can all have a conversation that can potentially move this case to resolution. Because for the benefit of Mr. and Mrs. Carson, if there's a lawyer, Mr. Taylor, and I've dealt with Mr. Taylor a lot of times on dispossessory issues in court. I know that Mr. Taylor has the legal ability and knowledge to move this case to where it needs to go.
Okay.
So I'm gonna place you all in breakout room number 2.
So do we come back to you after?
Yes, you can.
Okay.
And generally it's something where if you reach a resolution, you need to come back to me and tell me whatever has been decided so that I can at least write it down and memorialize it. And whatever moves forward from that moves forward from that.
All right.
Okay. So Miss Bridgewater and Mr. and Mrs. Carson, I'm going to place you in breakout room 2.
Sure.
And you're gonna get the link in a moment. Okay, so the two of you should have received the link. It looks like Miss Bridgewater's already moved in. There we go. All right. So now we're going to deal with Miss Woodby and Miss it says Johnson on the phone. I mean, not on the phone, but it says Johnson on my paperwork, but it looks like, is it Adeoye?
Yes, that's correct.
Okay. All right. So I'm gonna swear you both in. Miss Adeoye.
Yes.
Are you intending to try to call any witnesses here today?
Not at all.
Okay. Miss Woodby, your witness has been removed. Is that correct?
Yes, I sent her back home.
Okay. And if she needs to get called in, she can log in.
Okay.
But I want the two of you to raise your right hand for me, please.
Okay.
You swear affirming the statements you make during this proceeding shall be the truth, the whole truth, so help you God.
Yes.
Yes.
Okay. Miss Woodby, can you just give me a 5-minute overview of
The morning
of what your case is about?
The morning of May 18th, I went to check my mailbox. Going to check my mailbox, I saw my vehicle had been vandalized. I saw a wave of scratch from the driver's side to the back door on the driver's side, and then on the hood of the car on the driver's side, it's like a square, a squiggly line. That was the morning of checking my mailbox. So I went in, I have a Ring system that records my driveway, my front door, and my back. So I went to review my Ring camera to see what happened. Upon reviewing my Ring camera, roughly the night before the 17th, around between 9 and like 9:30ish, you see a gentleman come between my vehicle, because it was another vehicle in my driveway at the time. You see him go down, then you see him come back, and then when he comes back the second time, you see him key my car. And then before he drives off, you see him scratch the hood of the car and run. So I called the police, got my police report, advised that my vehicle was vandalized by a young gentleman that I seen in the neighborhood, because he fit the description. It's not that we have young gentlemen in our neighborhood, but none of his tall stature and broad shoulders. So I could tell that it was him because I seen him in the neighborhood before. So I, on my way home from work, I saw him and some of his friends playing basketball. And so when I went to ask him to speak to his mother, because I wanted her to see it, he said his mother was asleep. And I said, well, let me speak to her. So he tries to take me to another house that is not his. And one of his friends that he was communicating with at the basketball, he said, I'm taking her to my house. And he was like, you don't live there, you live over there. So one of his friends playing basketball told me the address where he lived at. So I went to the house, rang the doorbell, no one answered. So I assumed she was asleep because that's what he said. So 3 minutes later, while I was just waiting, he came, he goes in the house and nothing happens. He comes back out and he goes and plays basketball. So that's when I called for my second police report to advise that I had the physical address of the juvenile that vandalized my vehicle. And that's when the 911 operator advised me, since I had the address, to go back to my property and she would send a police car to my house. They came, they reviewed the video camera, they saw my vehicle, because this is the first time they actually came, because the first was just a call to report. So the second time they come, they get the report, they get the address and the video, and they go to the plaintiff's, the victim, the defendant's house. I don't know what happened. I go get my police report a few days later, and then off the police report, it states that the mother was coming to my house to rectify the issue. So she was coming to make it right. She does advise of his mental illness, but it does state that she was coming to my house to rectify. So rectify to me means make correct or return back to how it is. So she took blame then. I never heard anything. I've never seen her. She never came to say, ma'am, I don't think that's my son in the vehicle, until I went and filed charges because I hadn't heard anything. I was waiting on her. It's COVID. I understood, hey, it's a rough time. So I just gave it some time, and I was like, okay, I'm still driving around with my vehicle keyed. So I went and filed my complaint in November, and then I got another letter saying that it wasn't her son. But on the 18th, she said it was. So I don't understand. So that's why we're here.
So what actions were taken by law enforcement?
So that the officer had asked me if I wanted to press charges. I didn't want to press charges. He's a young African-American man. That's the last thing I wanted, because I have a young man myself.
Okay, can I speak?
No, stop. Miss Adeoye, this is a court. Okay, you're going to get your opportunity to speak about whatever you want to speak, but I can only listen to one person at a time. Do you understand that, ma'am? I need to hear a yes or a no.
Yes, sir.
Go ahead, Ms. Woodby.
So the police officer did ask, and as it states in the notes on the police report, I, as the victim, did not want to press charges. I just wanted his mom to be aware that her son was going around vandalizing vehicles and to take ownership and pay back for the damages to my vehicle. So no, they did give me that opportunity, and I denied it. I didn't want that to happen to him. He has mental illness. Why would I do that?
How old is the young man?
From what his friend that pointed to me to his house said, he was 14. I don't know.
Okay. And is that what you want to tell me, Miss Woodby?
Yes. And my witness was on her porch and saw the same thing, saw him come in between my vehicle. And she came, so how that happened, after she said she saw him, and then when she saw the police came, she said she didn't know what he did, but she can testify that she did see him running between my vehicle because she was on her porch. But she, at the night when it happened, she said she didn't know what he had done because she couldn't see anything, but she did see him run in between my vehicle and leave.
Is there any relationship between anyone in your house or family and this young man?
No, sir. It's just me and my 2-year-old son. I work from home, but no, sir, I don't know him.
Okay. Miss Adeoye, now you can tell me whatever you want to tell me.
First of all, my son do not come out in the night. So for anybody to accuse my son wrongfully should be held responsible on their end, because my son never keyed her car. He never even scratched her car. Now, whatever you have on your camera system, it might show a boy scratching your car, but you cannot prove that that was my son's face. Okay? There's a lot of kids in the neighborhood, but you cannot just point out that it was my son. Okay? There's no face on that video.
Hold on one second. Did you review the video?
Yes.
And you do not believe it was your son?
It was not my son. There's a lot of boys that look like him. There's a lot of high school, middle school kids that are in the neighborhood. And you cannot visually see on the recording the child's face. You cannot see the face. You cannot see that it was my son.
Hold on. Is there anything else, Miss Adeoye? Is that somebody on like a phone or something?
That's my mother. She was a part of the whole situation when officers came out to my home. So she was talking.
This is not proper. I see you got your kids, you got your mother there. I understand. Okay. What jurisdiction? Meaning, what police precinct?
Clayton County? Is that what you're asking? Clayton County?
Yes, it has to be Clayton County, but can you tell me where in Clayton County?
Well, I don't know the actual police precinct. Would that be on my report somewhere?
What?
I just doubt 911.
Jonesboro, Lake City, Morrow, where? Lovejoy. Okay.
Yes.
I was on the phone with the police chief from Lovejoy yesterday, and I'm going to continue this case for 30 days. I'm going to contact Chief Gaddis, and I'm going to have them to contact you, Miss Woodby, about the video. And I'm going to ask you to give the video over to Lovejoy for their CID to look at it.
Okay.
And I would stop if this young man is the person that did it. He needs to be prosecuted. I do not play with this. I'm not. I know it's like, oh, I want that. No, nope. You're gonna be prosecuted. If you did something wrong, you're gonna be prosecuted. If it seems like from what you've said that you tried to rectify the situation with Miss Adeoye, and she said, that ain't my son. Well, we're going to get CID to look at it. And if that's the son, he's going to be prosecuted. If not, then this goes away.
You go to jail, Mom? What you mean?
Are we clear? Because this is a matter that I hear what you're saying, Ms. Woodby, about you thought that this young man may have done something wrong, and you didn't feel like that this young man should be prosecuted, but you're coming into court and essentially prosecuting the young man.
Okay.
If this young man did this, he will be prosecuted, and the parents will be responsible for paying damages as to whatever was done. If this is not the young man, then the parents will not be in a position of being responsible. I don't know the young man. I would probably not be able to pick it out. As a judge, I'm not an investigator, but I do believe that right is right and wrong is wrong. So this case is going to be continued for 30 days. I'm going to contact Chief Gaddis, and if your son is the person that's in the video, ma'am, he's going to be prosecuted. If he's not going to be prosecuted.
Mm-hmm.
And that's all I can say. If you believe that he may or could be the person, you may want to try to resolve the matter before he gets prosecuted. If not, he's going to be prosecuted, and that's going to be a decision that you made. But I would like to tell you, ma'am, since we started this hearing, you've been drinking that water like it's the last thing on earth.
I have to.
Okay.
I mean, I have to. I mean, did you not see me take my medication?
Ma'am.
No, did you not see me take my medication?
I've seen you drinking water.
But I took my medication. Go get that medication. It's right here. It's right here. Did you not see me take my medication right here?
Ma'am, how does that matter?
No, you asked me why was I drinking so much water? Because I have to take it with my medicine.
Your response was, did you not see me take my medication? Your response was not, I'm drinking the water, Judge, because I've just taken my medication.
Yeah, that's what I said. I took my medication.
No, ma'am. You said, did you not see me take my medication? That's what you said.
Well, my apologies. I didn't mean to say it that way.
Well, ma'am, I'm telling you that you should be really certain that your child was not the child in that picture. Because if that is your child and the CID determines that your child is going to be prosecuted. And I'm gonna call and I'm gonna make certain that they look into it. Because if this woman's car was keyed by your child, you're responsible. If you want to try to shirk it off, that's fine. But you're going to shirk it off on the shoulders of your child. And if that's what you want to do, that's what you want to do. It's your child and it's your life.
My son didn't do it. You can't see the child's face on the video. Oh, he was wrongfully accused. There's a lot of kids that could have did. You can't just point out it's my son. It was in the night. You can't even see his face. How can you prosecute anybody when you doesn't even see the child's face on the video? You can even look at the cameras. You did not see the child's face at all.
I understand. And there are innocent people in jail and there are guilty people walking the streets. That's just the way the criminal justice system works. So I'm not trying to place your child in jail. But if this woman's car was vandalized and if she has the proof that she believes that supports the fact that your child vandalized the car, then she should be made whole. If she is wrong, the police will not charge your child. And so this case goes away. So I'm not trying to be for or against anyone, but I do believe that right is right and wrong is wrong. Okay, so I'm gonna have this case continue for 30 days. Come back to my calendar, and I'm gonna contact Chief Gaddis, and I'm gonna give him your contact information, Miss Woodby, and he will assign it to an appropriate person to look into it. Because she is right. Miss Adeoye is right. If her child didn't do this, she's not responsible.
You're right, sir, but she did also inform the police. So if not, she said she would rectify. So she lied to the police then.
There's no report that I said that. That's not in the report.
It's in the police report.
Stop. Both of you stop. I'm not here to litigate that issue. That is something that is going to be referred over to the law enforcement authority.
Thank you. Greatly appreciated.
To deal with. So, Miss Adeoye, do you have any questions about what I've decided here today?
You just want her to submit the video to the police department to verify if it was my son or not?
Well, I'm going to have them contact her to conduct a proper investigation.
Okay.
And whatever comes out of that is what comes out of it. I'm not saying your son did it, and I'm not saying that Miss Woodby is wrong. I'm saying that this should have been a matter that was properly investigated. And Miss Woodby, maybe that's a matter for you to understand in the future. I don't want to see anybody in custody. I don't want to see anybody in harm. But I don't have the power of Thanos to snap my fingers and then everything gets turned into the way it's supposed to be. But things have to be done in a proper manner.
Correct.
Okay.
I have a question, Judge.
Yes, ma'am.
If my son committed a crime, why didn't the police prosecute him then?
Well, so
it's not funny. I'm asking a question. It's not funny.
No. And I was going to respond. to your question. That's a totally legitimate question. Police officers, by and large, they don't put on a badge because they want to go place people in jail and in custody. And they would prefer for people to resolve their disputes with not having to have law enforcement contacted. So if a person says, I don't want to prosecute, police officers happy to do that. Because again, and I get waking up at 3 o'clock in the morning when there are emergency situations, and I have conversations with a lot of law enforcement officers. They don't want to place people in jail. So if Ms. Woodby said, I don't want to see this person prosecuted, they're happy with that, because that's not what they're trying to do. So I'll stop at that, and that's the answer that I can give to your question. Because the police have discretion; they don't have to arrest people. Sometimes they feel like they have to, especially in situations where there's violence involved. But they would prefer to not be in the middle of this kind of stuff. Okay.
Yes, Your Honor.
All right. So this is going to be continued for 30 days. I'm going to reach out to Chief Gaddis this morning. And do you have, what's your incident report, Ms. Woodby?
Scoot over. Don't let me tell you again.
Would that be the case number?
Yes, ma'am.
Okay, it is 210-289-37.
210-289-37.
Yes, sir.
Okay. And your proper name is Michelle Woodby?
Yes, sir. Michelle Woodby.
Michelle. Okay.
Yes, sir.
Okay. Miss Adioe, I saw two of your sons. You have handsome young men.
I can come. Can you choose?
How are you doing, young man?
Good.
How old are you?
Good.
You're 3?
No, I said it.
He what did he say? He said 7?
Yeah.
3? 7.
Yeah.
Okay. What do you want to do in life?
What
What do you want to do?
I want to go be a police officer.
He said a police officer.
That's a good profession.
Mm-hmm.
I hope you go through your life. You want to make your mother proud.
Okay.
Uh-oh, I saw another young man stick his head over.
Don't get
Uh-oh, now he's uh-oh.
Get into the camera. You're embarrassed. I'm not gonna take you to the basketball on Friday.
So listen, you all, I would hope you're gonna live a life that's gonna make your mother proud. And you can do whatever what you choose to accomplish in life. You just got to apply yourself. And you got to do the right thing. I know I'm an old man now, so, but I do believe that children are a wonderful gift in life, and your mother is a lovely person, and I want you all to try to live your life to make your mother proud. Can you promise an old man that?
Yeah.
Okay, thank you. So that's going to conclude this session with the result. This case is going to be continued for 30 days. I'm gonna reach out to Chief Gaddis, and you're probably going to get a call from one of his lieutenants, Miss Woodby. Okay.
No problem. Yes, sir.
Okay.
Thank you.
Have a good day.
You do the same.
Okay.
All right.
Thank you.
You're welcome.
Oh,
How you do it, Timothy? Get a press here. Wait, hold on.
I'll remove you. Okay. Sorry about that, Miss Bridgewater. Were you in the Carsons? Can the Carsons come back on?
We're back.
Okay. So what's the result of your conversation?
Well, we really didn't discuss a resolution. She kind of, I guess she was talking to somebody, and then she pulled up what we have on her computer, and she said she seen our move out inspection. Then she read off something else from that. She said that somebody went in behind the other lady, but we didn't sign off.
Hold on 1 second, Ms. Carson. I first want to know the result of the conversation, not the conversation.
Oh, there was no result. She said that she was just gonna come back to this room. I don't know her name. She's up the top, but she said we were just gonna come back to the room. There was no result on anything.
Okay, so there's no resolution.
No, we didn't talk about one.
Okay, Miss Bridgewater, you're muted, man.
I'm sorry. Ultimately, I told them that I would let you make the decision in this matter because at the time of their move out, I wasn't here. Based off of what she did present in her move out inspection, everything was labeled good all the way down, and the signature was signed by a leasing professional, Jennifer O. I'm not sure who that is either. With that stated, I show where someone else went into the home right after she moved out to conduct another walkthrough, and that's where I see the charges. So I don't know why it wasn't labeled on the move out inspection, but I see where it was cleaning charges, replace panel, trim repair, clean walls, front door jamb, animal urine in the back of the room, vinyl replace, back bedroom from pet urine. And those charges had come up to $2,397. And I see that the total owed by tenant was $1,547.22. But based off the evidence that she is presenting, it does show where the leasing professional, she did sign off on the move out inspection.
And doesn't that carry the day?
Yes, sir.
So it sounds like they're entitled to their money back.
Yeah, I agree based off of the thing, but I just wanted to come and, share the information with you because like I explained to her, I wasn't present at that time.
Thank you.
So
Thank you.
I'm just gonna ask a real simple question.
Okay.
Why don't they just get their money?
Honestly, this is my first time looking into her case as to this paperwork, to the things that I'm seeing today. I'm not sure. I don't know if she remembers a Val. That was the property manager. I've never met her.
Honestly,
Hold, stop,
I'm sorry.
stop.
I'm just gonna say,
Stop,
I'm
Miss
sorry.
Carson. No, stop,
Okay.
Miss Carson. I'm having a conversation with Miss Bridgewater right now.
Sorry, I wasn't gonna say nothing bad. I'm sorry, but I'll be quiet.
No, Miss Bridgewater, it's.
But look at
I'll say this. Life is easy. We as human beings make it hard.
Agree.
If there's documentation that shows on the date of move out that
everything was good.
It's just it's in my opinion, it's just poor form to go back and try to nitpick. There's I go purchase a car and I agree to make payments in monthly installments, and then 2 days later I'm like, you know what, I don't think I want to do that. And I'm still driving the car. That's poor form.
Agreed.
Can this be a consent judgment?
Sure.
Well, I'm not trying to break your arm. I'm just saying. No. It doesn't appear, and I appreciate your being straightforward with me. Doesn't appear like this is a situation that this is really complicated. With the fact that they're filing a court case, it just entitles them to more money from your company. And your company could have just paid them and been done with it. But I know it wasn't you. And I'm not saying it was you. So I'm not placing you in that category. Okay, Miss Carson, what is it that you are asking? There is a counterclaim that was filed.
And that counterclaim, I believe that counterclaim had my name on it. Do you see that?
Well, I can pull it up, but I see I'm just working off of like smaller document.
Are you able, will it take you a long time to pull it up, or is it work to pull it up?
No. Well, I mean, it takes a minute because the system works sort of slowly.
Oh, okay.
But I am.
But yeah, we are seeking the amount that I put on the letter. I'm trying to find it because she right. It's been I found this thing last year. But are you able to see the amount, sir? I'm not trying to be unprofessional, but are you able to see the amount?
But no, I can pull it up, and you're not being oppositional.
And thank you. I'm glad we don't have to go. And I'm saying this out loud. I know it's been recorded. I'm just happy that this case is finally over with.
Okay.
What was that noise?
That's the system that we're using. I think it's over 30 years old.
IBM.
No, it's called CPU-8, but it's so old that it's like a black screen with the green lettering on it. Like when I was in elementary school, like that kind of thing. So you're gonna hear some noises as it, which I don't know why it does it, but it does that.
Yeah, I know. I was just trying to help out.
Ms. Carson, we can still hear you.
Oh, I know I'm not on mute. I said I was trying to help. I was trying to. But I know. I didn't curse or anything. I know. Let me feel
No,
like
no, you did not curse, and thank you for not cursing.
you're not gonna give me no fire. No, sir.
So on your statement of claim, it says you're asking for $865 plus $500 interest, which prejudgment interest is not something that you can claim unless that was something that you contracted with.
Okay. So we just basically get our deposit back, and that's fine. That's fine.
Okay. So it'll be $865 plus $100 court costs. So it'll be a total of $965.
Okay.
Miss Bridgewater, I know you don't have a dog in the fight, but do you contest that amount?
Yes, with the counterclaim, I believe that's what this had something to do with, the cleaning and replacing panels. I think that's where that came in at. But as far as what is due to her, it's owed based off paperwork. It really is. I can't argue with that.
Yeah, the counterclaim, I don't think would be valid under these circumstances.
Okay.
Because it basically, the reason that she's getting a judgment is because the person signed off on it and said that it was fine.
Mm-hmm.
So I don't think you can come in after the fact and then say, well, it wasn't fine and we actually want this.
I honestly, I totally agree. That's not how I would have done things, but I agree with you.
I try to be fair. I try to treat people the way I would want to be treated.
Yes, absolutely.
So, Mr. and Mrs. Carson, that's going to be the ruling of the court: $865 in principal and $100 court costs.
Okay.
It's going to take about 10 days to get this stuff all processed in the system.
Okay.
I would, Miss Bridgewater, let your company know that
I will.
this judgment is there, and it, to me, it's probably like they would say, it's a rounding error for this amount of money, and they can just write a check and be done with it.
Agree.
Or Mr. and Mrs. Carson may be on an apartment complex. Okay, is there anything else that I can do for either party?
No.
No, not a, well. Oh, I'm sorry. Go ahead. You got something to say?
Oh, I was just saying, no, I'm clear.
Okay. And the only question I have to ask, so basically I don't have to worry about them trying to hit our credit, because credit is everything nowadays. So I don't have to worry about Hunter Ridge trying to say we owe them anything, correct?
I can't say that you can't be concerned or worried about that, but I can say that if they do something or place something on your credit after this judgment, that you will have the ability to sue them for that.
Okay. Okay. Well, you said 10 calendar days and it'll come to our address, correct?
Yes, ma'am.
Okay, thank you so much.
Okay. Well, it was great meeting both of you. I hope, or all of you, I hope everyone has a great day.
You too.
Same
Okay.
to you.
Goodbye.
Do I press leave or something?
No, I'm gonna remove you.
Oh.
Miss Kidwell, hold on. Thank you. Okay, do we have a Adrian Garcia or Marquetta McGregory in the courthouse? Okay. Position 2 is Waterford Place Apartments versus Angela Hicks.
Ray for plaintiff.
Okay. Now it's you, Mr. Taylor.
Move to strike at the appropriate time, Judge.
Okay. Is there Angela Hicks present in court? Okay. Position 3, you said it's going to be a dismissal. That's case number 2020 CM 13701. Marilyn Graham versus Marquetta Commander and Alik So, your Quinn. Position 4, this is the case with, we have the interpreter. Is it Ortega Pedro Ames or Pedro Ames Ortega?
Yes, Pedro Ames Ortega.
Thank you. And do we have Gregorio Rubin? Okay. Position number 5, Stephanie Gregory versus DeAndre Mitchell.
DeAndre.
See, Mr. Mitchell. And this, they have you as representing Mr. Mitchell. Is that correct, Mr. Todd?
Yes, Your Honor.
Okay. Is Stephanie Gregory present in court? All right. I see there's a counterclaim in this case.
Yes, Your Honor.
Okay. Position 6, Mark Welch versus Ray Anderson and Kashana Polk. Do we have Mark Welch present? Do we have Kashana Polk or Ray Kent Anderson II?
Ray Anderson, Ray.
Position 7, Marquetta Harris versus Fallon Buckland. Do we have a Marquetta Harris present? Do we have a Fallon Buckland present? Okay. Position 8, the housing group versus Adrian Smalls and Brian Norman.
Yes, sir. Byron Norman, yes, sir.
Okay. And ma'am, you're here on behalf of the housing group?
The housing group, Summer Shealing.
Okay. Position 9 is the housing group versus Olivia Bello Garcia. And Ms. Shealy, you're here on behalf of the housing group for this case? Okay.
Yes, sir.
Okay. Is there Olivia Bello Garcia? All right, position 10 is YCH Real Estate Services versus Robin Green or Roxanne Smith. Anyone here on YCH Real Estate? Is Robin Green or Roxanne Smith present? Okay. Finally, the housing group versus Sarah Bankston.
Here, present.
Okay.
Yes, Ms. Shealy again.
Okay. Okay. That completes the call of my calendar. Is anyone that expected their case to be called that did not hear their case called? Okay. Mr. Todd, let me begin with you since you have court at 9. Then I'm going to deal with Mr. Taylor, and then we'll move on. So it appears, Mr. Todd, that the plaintiff did not show up.
Correct. So if it's, I don't know if it's appropriate, Judge, of course, I would make a motion to strike their complaint. They failed to appear and enter a default judgment.
What's your evidence on the count? What's your evidence on the? Mr. Todd, Mr. Todd.
Judge, my client paid 2 months rent in advance.
Mr. Todd,
Yes.
I need you to find a better place. You're buffering so badly, I cannot understand you.
Can you hear me, Your Honor?
I can barely hear you. I cannot understand you, but I can barely hear you.
Okay, Judge, let me ask you this. Can you hear me better now?
No.
Let me see if I can. Okay, let me see if I can fix this problem, Judge.
Okay. Mr. Taylor, let me move to you. Your motion to strike is going to be granted.
John, I just.
Can you hear me any better, Judge?
No, Mr. Todd, I cannot. Go ahead, Mr. Taylor.
Your Honor, I just emailed you a dismissal on.
Judge, can you hear me any better?
No, Mr. Todd, no. Stand by, Mr. Todd. I'm going to try to get Mr.
Judge,
Taylor.
can you hear me any better?
Mr. Todd, no. Mr. Todd, can you hear me?
Yes, can you hear me, Judge?
I can. Stay right there. I'm going to deal with Mr. Taylor real quick so I can get him onto his next location.
Yes, I can hear you loud and clear, Judge. I can hear you
Okay.
loud and clear.
Oh, okay. Just I'm going to mute you for a second, Mr. Todd, so I can get Mr. Taylor out of the way. But you really need to find a better location than where you are. Mr. Taylor, you emailed the dismissal for a position.
Your Honor, I emailed to your email address a dismissal for position 3. On position 2, I would move to strike as for an immediate writ of possession and a judgment for $12,577.10. That's prorated through November the 13th of 2020.
Okay, I'm going to grant your motion to strike in your request for immediate possession of the property. And the amount, tell me that amount again.
The amount is $12,577.10. 12577.10.
Thank you. If you send me a judgment for that amount, I will sign it. And you can move on with your day.
That should be in the email that I sent to you about 5 minutes ago.
Okay.
Thank you, Judge. May I be excused?
Yes, sir. Okay, Mr. Todd.
Yes, Your Honor. Can you hear me?
I can't understand you, Mr. Todd. I can hear you, but you're buffering so poorly, so badly. It sounds like you're speaking at half speed.
Let me see if I can. Okay, let me see if I can get a, give me 2 seconds. Let me see if I can get it better, or I may be able to log out and log back in.
Try to do that.
It may be, I'm not sure exactly what it is.
Okay. Okay, try to do that. I'm going to move to position number 6, Mark Welcher versus.
Okay, I'm going to do that, Judge. I'm going to log out, log right back in.
Versus Ray Anderson, the second, Mr. Anderson. Since the plaintiff did not appear at the call of the calendar.
Okay,
your case will be dismissed for warrant of prosecution, and you are free to go.
All right, thank you.
You're welcome. All right, so we have 3 people at the courthouse. Position 1, I did not hear an announcement, so that case will be dismissed for warrant of prosecution. We've dealt with position 2 with Mr. Taylor and 3 with Mr. Taylor. Let's see. Position 7 is going to be a dismissal for warrant of prosecution. Miss Sheely.
Yes, sir.
Since you have 3 cases and you're at the courthouse, I'm going to try to deal with position number 4, because that's where I understand we have the need for the interpreter, with the last name of the case is Pedro, so that I can deal with them and then you can have the room to yourself with your 3 cases, and I'll let you speak to the people who are here to see if you can work out your matter. Okay. Mr. Mrs. Pedro, do we have the interpreter present?
I am present.
I'm sorry, ma'am.
I am the interpreter, Mariby Rojas Kimball.
Okay, Ms. Kimball, would you raise your right hand for me, please? Do you swear or affirm to the best of your knowledge, skill, and training you would translate these proceedings from English to Spanish and Spanish to English?
I do.
Thank you. Mr. and Mrs. Pedro, my name is Brad Gardner.
Our pleasure.
You are the plaintiffs in this case, but I did not hear that a defendant is present.
Ustedes son los. Sí. Ustedes son los demandantes. pero no está el que está levantando aquí presente. Yes.
For the record, this is going to be case number 2021 CM 02386. I need you to translate that, man.
You repeat that, please?
Okay, for the record, this is going to be case number 2021 CM 02386.
CM 0386. 86. Ok, para que tengan esto en su record es 2021C 1C M como María 0386. Okay. Thank you, Your Honor.
You're welcome. For the purposes of this hearing, will Mr. Pedro or be the only one speaking?
Por eso de esta junta es que el señor Pedro va a estar hablando.
Okay, pero no sé si usted le puede decir, yo soy la mujer que le puede explicar, pues.
But I am the one that can explain to you in further detail.
Okay. Would the two of you please raise your right hand?
Okay, los dos alzan su mano derecha, por favor.
Do you swear or affirm that any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Ustedes juran que todo lo que digan es toda la verdad y solamente la verdad. Sí. Yeah, juro. We do.
Okay. So I need to hear from hopefully one person.
Necesito que escuchar de una persona.
Okay.
When was the agreement entered into?
Cuando se hizo give me one moment, sir.
Yo no puedo ayudar.
No. ¿O cuándo fue el acuerdo? El acuerdo.
Okay. En junio del 2019.
June of 2019.
Él se movió a la casa.
That's when it was the move-in date.
Okay. En los 2 primeros meses, él pagó la renta.
The first 2 months, he paid the rent.
A partir de agosto, ya pagaba cuando él quería.
After August, then he would just pay whenever he wanted to.
En noviembre de 2019,
in November 2019,
él dejó de pagar la renta completamente.
He stopped paying the rent completely.
Hasta el día de hoy.
Until today.
No sé si le puedo explicar eso por pausa.
Do you want me to start explaining?
No. When is the last time you accepted payment from Mr. Rubin?
En octubre, ¿no? Octubre, último pago.
Noviembre.
No, noviembre ya no pagó. Parece que octubre.
October of 2021?
Octubre del 2021.
No,
2019.
October of 2019.
Yes, sir.
Okay. Is Mr. Rubin still in the residence?
El señor Rubén todavía está en la residencia. Yes, he still is.
Thank you.
Yep.
Those are heavy. Right here. We got
How much do you estimate Mr. Rubin owes you?
¿Cuánto es el estimado que usted quiere el señor Rubén les debe?
un mes.
350 a month.
Por un año, mucho calculador. Son cuántos son, de noviembre son 12. 12, noviembre son 12 meses, ¿verdad? No soy exacta. Este calculador ya no sé cómo ver esto. Ok. 350 por 12 después de 1.200. Y de noviembre, el año pasado, noviembre, diciembre, enero, febrero, marzo, abril. Estamos en mayo, ¿verdad? Son 6 meses más, ¿verdad? Ah, ok. 350. 350 por 6. 3.600, 6.300.
6,300.
How much was he supposed to pay every month? How much was the rent?
Tenía que pagar de renta mensual. $350.
Okay, I'm going to strike the answer.
Voy a explicar la respuesta.
Give you a writ of immediate possession for the property.
Si necesita posesión inmediata de la propiedad.
Sí.
Yes.
And enter a money judgment for $6,300.
Y entrar en su juicio porque de $6,300.
Sí.
Judge, can you let her know that they need to come in and pay for the writ of possession? The application of the writ, please.
I'm sorry, Miss Mosley.
And you advise them they have to come in and pay for the writ of possession, $25.
You will need to come to the clerk's office and pay $25 for the writ of possession.
Somete que ir a la oficina de clerk y pagar $25 para que hagan la paga.
Okay.
Okay.
Any other questions?
¿Cualquier otra pregunta?
Tenemos la puerta, que está rota del cuarto y tenemos tenemos muchas evidencias.
We have a door that is broken. And
I didn't understand that.
We have a door that is broken in the home, and we have a whole lot of evidence. If you need it.
How long has this door been broken?
¿Desde cuándo ha estado esta puerta quebrada?
¿Cuándo lo quebró?
Like 9 months ago, he kind of did it with a rag, pulling it.
Okay. I'm gonna leave the judgment the way that it is. You're just gonna have to fix the door.
Voy a dejar el juicio así como ordené, y Tomás va a tener que arreglar la puerta. Okay, that is fine.
Okay. You all can be excused. You will receive this judgment probably in the next, I'll say 5 days. Since you're at the courthouse today, you may want to go ahead and go to the clerk's office and pay the $25 for the writ of possession today.
Los van a expulsar, pero van a dar su decisión en 5 días, pero ya que están aquí, van a la oficina del Fleck, pagan sus $25 para que les dé esa forma.
Entonces, o sea, la decisión está tomada.
Ya está tomada.
Ah, ya, oigan. Okay.
I just wanted to clarify, decision has been made, free to go.
Yes.
Yeah.
And share the case number that I read out to you earlier.
El número que nos dio, que es el 2021 CM 0386. Ese es el número que vas a necesitar cuando vayas a pagar los $25. Okay.
Okay, thank you. You can be excused.
Thank you, Joanna.
You're welcome. Mr. Todd, are you in a better?
Okay.
Thank you, sir.
You have a good day.
You're welcome. You too, Mr. Todd. Are you in a better place for your reception? It does not look as so. Okay.
Judge, can you hear me?
I can hear you.
Yes. Can you hear? Yes.
Okay, I can hear you, but you are frozen on the screen.
Yes, Your Honor. Can you hear me?
Not really.
Judge, can you hear me?
I cannot.
Okay, I'm in a better reception area.
Yes. Okay, Miss Sheely, I'm going to, let's see, place you and Mr. Smalls. I'm going to place you and Mr. Smalls in breakout room number 1 so you can have a discussion about your case and see if you can resolve your matter. Mr. Smalls, you're going to see.
Can you hear me and see me, Judge?
Mr. Todd, this is really getting, this is beyond being comical at this point.
Can you hear me and see me?
No, sir. Okay.
Can you not hear me? Hey.
Let's see.
I don't know, Judge. I can hear and see you, no problem.
Okay. I got Mr. Smalls and Miss Sheely.
Mr. Norman as well.
Well, yes, sir.
Okay.
Okay, I'm sorry, Mr. Norman. Okay, you should be able to see a link. All right, so Mr. Todd, while we've been trying to get you connected, Miss Gregory has showed up. So I can place you and Miss Gregory and Mr. Mitchell in a room together.
Did Mrs. Gregory show up?
Yes, sir.
Oh, okay.
So I'm going to place the three of you in breakout room number 2 so you can have a discussion and hopefully you can resolve your matter.
Okay.
Miss Gregory, you should receive a link now on your computer. You press the button
I'm
or
sorry,
the
Judge,
link.
are you speaking to me?
I'm sorry. There's a Stephanie Gregory. I'm going to come to you next, Miss McGregor.
Okay, sorry.
Miss Gregory, you should be able to click on a link.
Click. I just see where it says join.
Yes, ma'am. Join room 2.
Okay, thank you.
You're welcome. Miss McGregor?
Yes, sir.
Could you turn your camera on, please, ma'am?
I'm trying to. I don't know what I need to do. It's not giving me a prompt. It just tells me, okay, it says I started the video.
Okay.
Oh, I see it. I'm sorry. Wait. No, that's a breakout room, I think. I'm sorry.
Okay. Well, no, Miss McGregor, I was just going to tell you that the plaintiff did not appear today, so your matter has been dismissed.
Okay. Thank you.
Okay, you're free to go, ma'am.
All right.
And Ms. Bankston, when Ms. Shealy is done speaking with Mr. Smalls and Mr. Norman, I'm going to place you in breakout room number 2 so you and I can have a discussion, okay?
Okay.
All right. Sir, there is a counterclaim that was filed. Ms. Gregory, I've never had the opportunity to address you directly because you logged in late this morning. So, ma'am, I'm gonna swear you in and I'm gonna swear Mr. Mitchell in. And I want the both of you to raise your right hand for me, please. Do you swear affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Okay, so this is a situation where Ms. Gregory has filed a claim. Mr. Mitchell has responded and he has a counterclaim. So as it relates to the original claim, Ms. Gregory, I need you to tell me why you should receive this $800 or not be responsible for repaying the $800 to Mr. Mitchell.
Well, Mr. Mitchell entered into an agreement verbally with my son, Noah. They had a falling out and I got involved. I texted Mr. Mitchell and asked him if he could resolve the matter with my son or if he could vacate the premises because I didn't want any problems. Mr. Mitchell responded civilly and in that moment and said he was going to attempt to try to resolve it. Then Mr. Mitchell turned around and stated to me that he didn't, why should he have to move? He was going to destroy my son. He was going to have me arrested because I came onto the property. He had about 7 cars parked on the side of my house and in my driveway to where We couldn't even get a car in the driveway. There were packages on the front porch, all over my living room, all over my furniture. And I asked him to leave because I didn't want him to have eviction on his record. Mr. Mitchell at that time said he wasn't. And after he started, he made the threat against my son. I called Clayton County. Clayton County told me that if my son had allowed him to be there and he had given him $25, it didn't even matter, that he was entitled to be there. The only way I could get him to leave the property was to have him evicted.
Okay, so hold on. You have the address listed as the same for both yourself and Mr. Mitchell. Do you live at this Winewood Way home?
I don't physically live there. I go there from time to time and stay. That is my house. I own that property.
Okay, hold on.
Okay.
And I'm just stopping you for us to try to walk our way through this, okay?
I understand.
So first thing that I have to do is to establish that there is a landlord-tenant relationship. Was there a lease between, you said your son allowed him to live there?
Correct.
And there was no lease?
No.
I'm going to ask this question carefully. What is the relationship between your son and Mr. Mitchell?
They met when my son was in college. Mr. Mitchell got into some trouble with the law, whatever.
So, stop,
okay.
Gregory.
Okay.
So I'm asking, are they friends? Are they lovers?
No, they were just acquaintances. And he allowed Mr. Mitchell to be there to get on his feet.
Okay. And when did that happen?
I'm not sure because I wasn't privy to the details until after the fact, until there was a problem. I had a neighbor to contact me and say,
Judge, we're gonna object to what the neighbor says. That's hearsay.
Mr. Todd, I understand. Please, I'm trying to work myself through this. Okay.
I was just informed that there were a bunch of cars in my yard.
Okay.
And when I inquired with my son, they were just friends. They were acquaintances.
So, Miss Gregory, the first thing that you have to do is establish a landlord-tenant relationship. And it appears as though your son was allowing Mr. Mitchell to stay there with no landlord-tenant relationship established.
Correct.
So you got to first take the steps to establish a landlord-tenant relationship, which means if Mr. Mitchell is staying there and it was just because friends rely on friends to stay there, the first thing that you have to do is present Mr. Mitchell with the lease. And if Mr. Mitchell refuses to sign the lease, he gets 30 days to stay there before he can be evicted.
Correct. So the lease part never came into play. But when I went to Mr. Mitchell, it was the end of March, and asked him, what would it take for him to get himself together to be able to move because the relationship wasn't working out. And I didn't want nothing negative to transpire between him and my son, which could cause hurt or harm to either one of them. Mr. Mitchell refused, and I contacted Clayton County, and they told me the only way that I could say that Mr. Mitchell couldn't be at my house.
Ma'am, let me stop you. Because when you say I contacted Clayton County, I need to know who you contacted, what department, what agency. It's a whole county. So
I contacted the sheriff's department.
Okay.
Contacted the sheriff's department.
Okay. So have you or your son ever presented Mr. Mitchell with a lease?
No.
So I don't believe that you can establish a landlord-tenant relationship such that dispossessory becomes an option that is available to you.
Okay, well, I look, Judge, I don't have any experience with this at all. And when I went to the sheriff's department, they said that they weren't an attorney, but if he was in my home, I wanted him out of my home. The only way I could do that legally and to be in order was to file for an eviction. And that's what I did.
Which I understand, but the police are not lawyers.
Yeah,
And
exactly.
so the first thing that you have to do to be able to perfect your rights and assert your rights is you have to establish a legal relationship.
Okay. I didn't do that.
No, and Miss Gregory, and you're not the only person. And I have friends. I tell them all the time, if you're gonna have somebody living at your house, you can stay till Friday. And then on Friday, I'll decide if you can stay to the next Friday. And at next Friday, I'll decide if you can stay to the next Friday, because that does not establish an expectation of the person having a place to live. Public policy in the state of Georgia is that we don't want people to be thrown out on the street. So we have this whole dispossessory process that establishes a legal method to move people out of a home when that person either is not paying according to a contract or an agreement, or because the agreement is in place, but the landlord has decided they want the person to leave, but they have to follow through with what they place in their contract. So it's just not a situation of just moving people out. Am I making sense to you, ma'am?
You make perfect sense. It's just that I had no knowledge of, nobody gave me that piece of the puzzle. I just acted in a sense to try and protect my property and my son. And that's what I did in the situation. The young man had paid rent for May and June to my son. I never received a dime from him.
Mm-hmm.
I never gave him permission to be there. I never agreed to him being there. I didn't know that he was even there until way after the fact. And when this happened, this is how I end up here.
I understand. It appears from what you've testified to is that your son had apparent authority to give Mr. Mitchell the right to be in the home.
I don't know that he did. I mean, I have strongly suggested to him that he not allow anybody to live there with him because, especially people that you don't know that well, and obviously he didn't heed to that instruction. And there's nothing I can say about that. I mean, we find ourselves here. Mr. Mitchell did stay there until May, and he had given him money for that period of time. And yes, I did file the thing because I had just simply asked him to leave, and that didn't work. And then he started telling me that he was gonna have me arrested. He sent a text message this morning to my son's phone saying, LOL, I'm gonna send you to jail. I mean,
that's neither here or there.
Yeah, I mean, I just didn't want to deal with all that kind of stuff going on.
Hold on. Does your son stay at this property?
He does.
And your son allowed Mr. Mitchell to come to the property?
He did.
Okay. So my understanding of the law is that somebody is going to need to present a lease to Mr. Mitchell, where he can either agree to the lease or he can just say he's not gonna agree to it. And after that point, you 30 days later, you begin to be in a position where this would be a right, as we would say, this would be something that a judge can sit down and listen to and deal with.
Okay, but he's left the property, so I still need to present him with the lease in order to resolve the matter.
Mr. Todd, is your client still in the residence?
Judge, he's left the residence now because she filed this. He's left that because of the issues and the problems that were there, and I guess the threats that they were going to evict him irregardless. So he now has left the property.
And
but again, he had paid for May and June, and her son was the one that was allowing him to stay there. And so that's the basis of my counterclaim, the fact that they wrongfully evicted him, and they still had accepted the money he had paid the June rent in advance.
Mr. Todd, your Wi-Fi or whatever you're on is very poor.
And the fact that they filed this and did what they did, they still, or he did.
Okay. So,
Judge, I apologize. I've never had a problem with it before, so I'm not sure what's going on today, but.
Well, it's better now. That last sentence that you just gave was perfect. I could understand it.
Okay. I just picked it up and put it in my hand is all I did. So, but can you hear me better now?
I can hear you better now. I'm going to call you, you're going to be attorney Edward Scissorhands, because apparently if you're touching your phone, you're interfering with the ability of your phone to pick up. So it appears, and correct me if I'm wrong, Mr. Todd, but it appears as though this is not ripe for a determination as to whether there is a landlord-tenant agreement.
Well, Judge, I guess the problem is that there's an apparent landlord agreement, not necessarily between Mrs. Gregory, but her son stays there, and she allowed the son to have an apparent authority in this matter. And he rented it, or however you want to classify it. He rented the property to my client and accepted rent. He paid utilities. I think he paid the trash, and he also paid a couple of the other expenses there. So I think that what we really have here, Judge, is it's not with Mrs. Gregory so much, but she apparently allowed her son to, from what she's testified to her own testimonies, she's allowed her son to rent the property out to whoever he desires.
No, I didn't.
Stop, Miss Gregory. Miss Gregory, stop. Everybody speaks one at a time. Okay.
Sorry.
No, go ahead, Mr. Todd.
Yeah. So what we have here, Judge, is from what she's testified, just her testimony alone, is she doesn't really live there. She owns the house, but she doesn't live there. But she allows her son to lease the property, to have control of it. That's what he did. She knew that he was there months before, and she never took any action prior to that time. I mean, as soon as she found out about it several months ago, why did she not take action at that point in time? No, she allowed the son to have what I call apparent authority. And he did, in fact, act as a landlord and basically rent the property to my client. And so therefore, he paid the rent to him. They accepted it. No objection from not only the son, but the owner of the property. She was aware of that my client's staying there. Okay. Now, when they got into an argument, for whatever the reason, when her son and my client got into some kind of disagreement for whatever the reason. Now she wants to kick him out at that point, but not only did she not proceed correctly, Judge, but they now withheld the money. I mean, he paid for June's rent, and it's clear that he didn't stay there in June. So they accepted that money, but yet she would have no authority at that point to have filed an eviction. The rent was already paid for May. For May, the rent was paid, and she evicted him out. And now they got June's rent on top of that, and they evicted him out of there. So they're the ones that got the issue and the problem. It's a wrongful eviction to begin with, and then they accepted rent in advance for May, not only May, but June. You know, he vacated the property, yes, but they maintained and retained his rent for May and June. Okay, and she's testified that, you know, whatever, and I understand, but that doesn't excuse her ignorance. There's no excuse for the law. I understand she's a layperson and what she did, but, you know, obviously this filing that was wrongful, Judge, a wrongful wrongful dispossessory, and knowing, in addition to that, that the rent had been paid for May and June. You just can't do that. If you accept rent, you can't be having it on both sides of your mouth, you know, accepting the rent, evicting somebody, and withholding their money. So they're the ones that got the big issue and problem here. So
hold on, Mr. Todd. Ms. Gregory, I see you. You don't have to, we're not in church. You don't have to keep your hand up. When Mr. Todd is done speaking, I'm going to come back to you. Okay?
Okay.
All right. Go ahead, Mr. Todd.
Yes, Judge. So as a result of that, again, I think we have a apparent authority here, and we do have a lease, although be it verbal, between her son, who I think he's given her apparent authority, and my client. And my client, they were acting as landlord-tenant. My client was renting it on a monthly basis, paying the rent, which he did, and paid the utilities, which he did. And so therefore, I believe that there was a verbal agreement between my client and the son, who had apparent authority from Mrs. Gregory, who's already basically testified to that. Okay. And the only reason they evicted him, Judge, quite frankly, is whatever disagreement that her son had with my client. He didn't have any contract with Mrs. Gregory or an agreement or a lease with her. Okay, Judge, but all she is the owner of the house. Okay, just like me, I own a house. If I allow somebody else to live there and allow them to rent it, sublease it to somebody, even though it's verbal, I mean, that's what we have here. And unfortunately, I mean, I understand her situation, but unfortunately, she should have never proceeded this way because obviously, as the court knows, you know, it's not correct, both legally and justifiably, it's not correct. And then I said, again, she's got right now, he could walk back in there if he wanted to. He's got the rent for June. He's already prepaid that, and they're holding on his money. So,
which and I'm gonna stop you, Mr. Todd.
Sure.
I understand your argument. I'm gonna listen to Ms. Gregory, but after I listen to Ms. Gregory, I'm gonna make a ruling. Go ahead, Ms. Gregory.
Okay. First of all, I never gave my son the authority that he could let somebody live there. Secondly, I didn't know Mr. Mitchell was there. Thirdly, he never paid a utility because my son and I arrangement is that one where when he get paid, he deposits money from his check into my account and I can support that. And all the utilities at that address are still in my name and I pay the utilities. So he never paid a utility bill, first of all. Whatever their agreement was, whatever he paid him, from my understanding is that he had paid rent in March ahead for in March for April and May. And this all started at the end of March. Okay. He vacated the premises at the end, at the middle of May. So at most, he left, we just talking about the rent aspect of it. He was there part of May. He stayed there all of April and he stayed there part of May. Now, There was some other stuff that I didn't do right, but what he stated was incorrect. I didn't have any knowledge until March that this man was in my home. And I never gave my son authority to have somebody there to collect rent and or otherwise. So that was not the case.
Well, Miss Gregory, you may be in a position where you got to pursue a money judgment against your son, because there's something that's called a parent authority, meaning if I show up at your house, you got a key, and I ask if I can stay here, and you say, sure, I have every reason to believe that you have the authority to let me in the house and let me stay. If there's an agreement that was, we'll call it a side agreement between your son and Mr. Mitchell, that's something where it's between you and your son. It's not between Mr. Mitchell. If Mr. Mitchell is in a situation where there appeared to be a parent authority and he paid money in good faith, Mr. Mitchell may be sitting on a claim of wrongful eviction, meaning he paid money to stay here. And then when you say, well, I never gave my son that right to do that, so he may be able to pursue a claim against your son for wrongful eviction. As it stands, this is going to be my order. Because there's not a landlord-tenant agreement that's been established, this matter is going to be dismissed. You can take the steps necessary, Ms. Gregory, to establish a landlord-tenant agreement with Mr. Mitchell, but it appears that he's already moved out of the residence. So to that extent, you may want to be in a situation where if there's any monies that are alleged to have been owed, that you or your son make Mr. Mitchell whole as to any monies that may have been provided where he was not there in the house. That's not going to be something I'm deciding today because there's no landlord-tenant agreement that's been established. If you take the steps to establish landlord-tenant agreement and you want to come back, then those issues are things that at that time will be right to be heard. Do you understand what I'm saying?
I kind of do. I really do. I'm missing something.
Okay.
I don't know if you instructed me that I should reach out to Mr. Mitchell and offer him a lease, although he's gone, and then say, can you move now that I have the lease? I don't know.
So the problem in this interaction is that as a judge, I can't give you legal advice. So I can't tell you what's the right thing or the wrong thing to do.
Okay.
Because then it'd be, Judge Gardner told me this is what I need, just like when you said the police officers came down.
Right.
If this is a matter that you're going to pursue, you may want to speak with a lawyer and someone that can just give you advice as to what to do. But if what Mr. Todd has said is correct, there may be monies owed to Mr. Mitchell. And if he said what he said is not correct, like if he's already paid for rent in June and he's not there, he may be entitled to a refund. And I don't know, because I'm not reaching yet. I'm not dealing with that right now.
Okay, I got you. I understand. I understand that. Okay. I understand that.
Your Honor, do I have the opportunity?
I'm sorry, Mr. Mitchell.
Do I have the opportunity to speak real quick?
Well, I'll say this. You have a lawyer, and I generally don't allow people to speak without first knowing what their lawyer not knowing what they're going to say. So is what you're trying to speak about, does it have anything to do with the facts of this case?
Yes.
So you should speak to Mr. Todd, because
Judge, I'll ask him a question or two, and that way he'll be able to expound on that.
Okay, go ahead.
That way he'll be able to at least, Mr. Mitchell, will you explain to the judge about the money that you paid for as far as the rent and also the utilities?
Yes, sir.
Mr. Mitchell, can you hear me?
Yeah, I heard you.
Okay.
I paid the money to Noah, which is her son. Miss Gregory was well aware that I was staying there. I met Miss Gregory when I first moved into that home because she asked me for my assistant to help move some furniture. And me and her son have traveled to her house multiple times to help her with things. He is a trash can that we took our trash to. So her saying she
Miss Gregory, you're in court, Mr. Mitchell.
Okay.
You're getting into underlying facts of the case, and it matters to me none whether she knew you were there or she didn't know you were there. That has nothing to do with whether there is landlord-tenant agreement or whether there are monies that are owed.
Okay.
I was just going to ask him, Judge. That's why I asked him the question. I mean, he kind of didn't answer it directly, but did you have a landlord-tenant agreement, a verbal agreement with her son, Mrs. Gregory's son?
Yes, sir. I have one with Miss Greg, with her son. Yes.
And how much were you to pay the rent? How much was your rent payment?
It was 500 a month, 400 a month. I apologize.
Okay. And then did you also pay for some of the utilities?
Yes, sir. I cashed out Mr. Gregory for the Wi-Fi. I've cashed out him for the water. I had to pay for the trash services myself.
Okay, Mr. Mitchell, let me stop you. In the future, if you're gonna create an agreement where you're gonna be living someplace and paying rent, sign a contract.
Yes, sir.
John, because we just get into this, he say, she say, I didn't do that, it was this, it was that, or blah, blah, blah. As a judge, I cannot look or listen to someone saying, yes, I did, no, I didn't. Does that make sense to you?
Yes, sir.
Because I'm meeting you for the first time here today. So, and I'm meeting Mrs. Gregory for the first time here today. So when we get into all of that stuff, you put yourself in a bad situation. I mean, so it's and I'm sorry, Mr. Todd, but I'm not here to decide whether the blue smoke or the black smoke is telling the truth.
Oh, I understand.
I want agreements, and I want something in writing with signatures, and people can stand behind it. Because other than this, we're just on Jerry Springer.
Well, Judge, the only reason I say that is because of the fact of he has receipts that I've introduced or will introduce into evidence. The court would like that I provided the court showing what we're stating in this case. I think that the court would make its ruling whatever, but there was apparent authority here that has been undisputed by Mrs. Gregory. Okay, so and then furthermore, okay, Mr.
It wasn't Miss Gregory did not agree that she allowed Mr. Mitchell to live there. So it wasn't established by Mrs. Gregory.
Okay. Well, and then subsequently, Judge, I mean, obviously my client through his testimony is establishing that unrefuted that he had a rental agreement with her son. So her son is not here as a party, but there's no dispute. The evidence that's being presented to the court is basically undisputed, that she allowed her son to not only live there, but to allow him to do what she did, for him to rent the place. So, but more important,
Mr. Todd, her testimony was that she did not allow Mr. Mitchell to stay there. Your testimony has been that Mr. Mitchell had permission from her son to live there. So there's conflict in the testimony.
Okay. Well, then be that as it may, Judge, that there's conflict in the testimony, but there's nobody here to dispute the fact that he paid the rent and they withheld the rent or the money. He paid the money to them, however you want to classify it, for May and June. And they withhold his money. So the point being, Judge, is I believe on the counterclaim that we have a valid, not only valid argument, but valid facts to show that they, under the basis of that, they withheld his money. And it can't just be because they didn't proceed properly and they didn't do what they're supposed to do, that my client should be jeopardized or my client should be prevented from that. I think it's clear.
I disagree. I disagree with your position. And I would ask, why doesn't Mr. Mitchell just sue Miss Gregory or the son for the recovery of the $800?
Well, I mean, we may have to do that, Judge. All I'm saying, this case is currently pending for that specific reason, meaning that's the facts of this particular case. That's why he filed the counterclaim, is because of the fact that for the reasons I've already stated. Obviously, he may have to proceed forward if the court does not give him relief today, Judge, depending upon what the court does with this case, then yes, he may have to file a separate lawsuit against either one or both of them, whatever the case may be, to recoup his monies. But since it's pending in court right now, based upon the information provided to the court, we can't do that just yet. But I believe that they cannot have it both ways. They cannot accept the money, withhold the money, and then, I mean, how are they holding the money? Under what basis do they have to withhold this money? None.
I'm not reaching that issue today.
I understand.
And if so, based upon what you said, Mr. Todd, is that Mr. Mitchell was asked to leave and he left, correct?
Correct.
Is it possible that he left because he believed that he didn't have a right to stay there?
No, Judge, he already prepaid the rent for May and June. Why would he not think he would have the right to stay there when he paid a month in advance?
Which is an issue that will get reached if this is properly before the court. But according to what you're saying, Mr. Mitchell can go back and
yeah, he can
plop up in the house. He got until the end of June,
right?
To do that.
Yeah, he could do that.
So
from a practical standpoint, I'm sorry, Judge, I didn't mean to interrupt you.
So there are two possible outcomes. Through this verbal agreement or whatever with Noah, it was not all that he may have represented to you, or he told you the God's honest truth, and Noah and his mom are trying to cheat him out of $800. Those are the goalposts, correct?
Yes, Judge, based upon not only the testimony, but the evidence of his payments for the not only the rent, but the utilities, and the son's emails that you have in this matter indicate that he asked him for $60 for the internet for May, as an example. There was a $155 payment for the trash pickup. There was $400 payment for the rents. So all that is there before the court, and the documents presented to the court.
In a case where there is no landlord-tenant relationship established, just because your client said that there is a landlord-tenant relationship, it does not carry today. I mean, had Mr. Noah been subpoenaed and came in and placed under oath and said, yes, these are the terms of our agreement, then you're where you're trying to go. But your client's testimony that there was a landlord-tenant agreement to try to get to the counterclaim in the face of testimony from Ms. Gregory that there was no landlord-tenant agreement. I'm just trying to get this, as they would say, get this back on the track. Get it back on track where it needs to go so it can be properly dealt with. If Mr. Mitchell believes he has a strong claim, file a lawsuit, come back and get legal fees and get court costs. And that's as simple as I can make it.
Well, I understand, Judge. Yeah, it's a question of fact regarding the apparent authority. That's a question for fact for the court to make that determination. I understand that, Judge, and you know, based upon that, and then based upon what we have, you know, my client would have a right to, depending upon how the court rules, would have a right to pursue a separate action, you know what I mean, for reimbursement for what is there. But that's currently what's pending before the court. So
right, and the claims that you made in your answer and the counterclaim, they will be valid within the confines of the case being placed in the appropriate location. And as a judge, you try to put the square blocks in the square hole, the round blocks in the round hole, and you try to keep everything on track so that you can understand and you can make a determination. But when you start trying to put the round hole in the square peg and all of that stuff, it causes problems. And I have done that. And I'm not saying that I'm perfect in this, but whenever I put the square or the round circle in the square peg, I always have to come back and undo it. So my position is that I'm not wanting to undo it. If Ms. Gregory believes that her claim is fine, then she can refile. Mr. Mitchell is out of the home. If he has roughly $800 or whatever that he's paid, he can go after, well, it'd probably be the son and not Ms. Gregory, but because as I've heard today, there is no agreement between Mr. Mitchell and Ms. Gregory as it relates to that home. So it would be her son, Noah. And so Ms. Gregory, the purpose of having this long-winded discussion is that if Mr. Mitchell paid monies to your son to be in that home until June, and he was essentially asked to leave, your son is going to be liable for that.
I understand, Judge. I will convey that to him. I think you're stating that he would be liable. He left in May of 2020, and if he paid Noah for June of 2020, then he's entitled to that $400 back. Yes. And I understand that. I will speak to him because, like I say, he never paid me anything. Okay, well, so we're not gonna go back to that. But right. I will address my son, and hopefully he can do what needs to be done in that situation. And
do you have Mr. Todd's contact information?
I don't have Mr. Todd's contact information. No, I do not.
Mr. Todd, is your number 770-477-7878?
Yes, Your Honor.
Okay.
And all that information is contained in the counterclaim, my address, telephone number, but that's correct.
Okay, so Ms. Gregory, I would encourage you to have just a frank conversation with your son, because it's better to just wipe your hands clean and move on from this.
And I agree. And that's what I hope to do. Could you repeat that number again, if you don't mind?
Yes, ma'am. It's 770-477-7878.
Thank you so much.
Okay. And just make sure, you have a frank conversation with them, and just let them know that, if based upon what Mr. Todd said, if that's correct, Mr. Mitchell is entitled to have that money returned to him.
I agree.
Okay. All right. Is there anything else on this case?
No, Your Honor.
Okay. Everyone have a good day.
Thank you so
much. Judge,
much.
are you going to enter just one question, Judge? I'm sorry, follow up there. Are you going to go ahead and enter the order in this case? Or do you want me to prepare one, or what do you want? How do you want that handled?
I would love for you to prepare an order, and the case is dismissed because there is no landlord-tenant agreement, but is not dismissed with prejudice. It's dismissed without prejudice. And if Ms. Gregory refiles, it seems like that may be it'll be something different, but Mr. Mitchell is no longer in the home. And it appears that the only issue outstanding is the amount of money that you allege your client paid before he, or prepaid before he left the residence.
Okay. I'll prepare an order to that effect, Judge, and I'll submit it to you, and then you can review it. If it meets with your approval, fine. If I need to make any corrections, I'll do it just like the court. The case is dismissed because there's been no landlord-tenant relationship established, and either party can pursue whatever lawful means or legal means available to them. Something to that effect. So I'll put it without prejudice.
Yes, sir.
So either party can pursue whatever rights they have. Either party can pursue them. They're not foreclosed. She's not foreclosed from filing an eviction, and we're not foreclosed from filing a civil action to recoup the money.
Yes, sir.
Okay.
Okay. Everyone have a good day.
Thank you so much.
Yeah.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Because of the I pressed the wrong button and it was asking for password. And I'm a person where
that worked, Judge. You're good.
Okay.
That worked.
Passwords, you would just have maybe 2 or 3 passwords. Now it's like 25, 30 passwords. I have to try to keep in line with everything else that goes on in life. And I'm like, at least my brain is not capable of keeping like all those passwords in place. So that's a constant conversation I have with my wife. I'm like, I just need to if she can put a bicycle helmet on my head, I'll be perfectly able to do what I need to do. Other than that, it causes problems. So we are now live. Today is May 9th, 2022. This is the afternoon civil motions calendar. My name is Brad Gardner. I'm magistrate judge. I'm going to be presiding over the calendar here today. I'm going to call a calendar. When you hear your case call, please give me your announcement. If you need time or you would request an opportunity to speak to the opposing party where you possibly could resolve your matter, I will give you that opportunity. And I encourage everyone, if you can resolve your matters, do that. Because as a judge, I'm going to make a decision, but decision I make may not be the decision that you like. Okay. Position number 1 is A to Z Auto Services versus Lake City Auto Sales.
Yes, Your Honor, Attorney Saadia Ali for A to Z Auto Services, and I have a pending motion for withdrawal from this case as counsel, and I've also submitted a proposed order granting that motion. That motion has been pending since July of last year. I can no longer continue to represent the plaintiff in this case for personal familial reasons, and I'm not exactly sure as to the current status of that motion and what we can do to move forward on granting my withdrawal from this case.
Okay. Is there anyone from Lake City Auto Sales or insurance auto auction here?
Yes, Your Honor. Michael Williams on behalf of Insurance Auto Auctions. This case was dismissed a couple of years ago. I think there's a pending motion to set aside the dismissal. However, we certainly don't object to counsel's withdrawal. And if the court wants to go ahead and enter that order allowing counsel to withdraw, we certainly would consent to that.
I will, Ms. Ali, I'll go back onto our internal system and see that motion that you filed, and I will certainly grant it. I don't know why you're here, but not why you're here, but it should have been granted, your motion to withdraw. And I do apologize for that. Mr. Williams, do you think that this affects the underlying action, or?
I don't see that. I mean, so the case was dismissed by the court back in December of 2019. I think at some point in 2020, the plaintiffs sought to reopen that case or set aside that dismissal. So, I mean, I don't know what the court wants to do. I mean, with regard to the outstanding motion to dismiss, we don't think that outstanding motion set aside. I mean, we certainly don't think that that's got any merit or that the court should set aside the dismissal, but that shouldn't impact the counsel's withdrawal.
Okay.
So, Honor, if I may step in for just a moment, the case had been dismissed because the plaintiff's prior counsel, and I know I have a pending motion to withdraw, but as prior counsel who still has not been withdrawn from the case, I do think it's my responsibility just to clarify the issue prior counsel that the case was dismissed because the plaintiff's counsel had not informed them of a hearing, thus causing the plaintiff not to arrive for that hearing. And a motion to set aside that dismissal was submitted. And then I believe everything with COVID that was going on and with the cases kind of taking precedence over other emergency underlying it, we did request hearings a few times, but as soon as we ended up having the issue of my withdrawal, we were up for a hearing at that time. And during that hearing, it was on July 20th, I did ask Your Honor for my withdrawal as well as a continuance so that the plaintiff could find another attorney. The continuance was granted, but my withdrawal was not. And I think that this just might have something to do with paperwork, but I can definitely re-email that order that on its own merits, that's something that needs to be heard by the court in regards to the actual merits of that motion to set aside. But I unfortunately am not in a position to be able to represent the plaintiff for that hearing.
And I understand. And so Your motion to withdraw, it will be granted. And I understand you
Thank
have
you
to.
so much, Your Honor.
I understand, you're welcome. I understand you have to protect your client's rights, and I will take a look at the issue. But if there was a dismissal that was granted back in 2019, the case may stand dismissed. And of course, it'll be without prejudice, and whatever rights any person has, they can exercise those rights. But I'm not gonna hold you in a position, Ms. Ali, where you're having to stay on a case that you're asking be withdrawn upon. And Mr. Williams, I'm gonna look at it, and if it was dismissed, it was dismissed. So we'll try to see where it stands. So
Just for the court's edification, in our answer, there's a mandatory arbitration clause in the contract case. There's a mandatory arbitration clause. So I don't know what the court wants to do with it, but the case was dismissed back on December the 18th, 2019.
well, I'll tell you this. I don't reopen stuff. I got enough stuff to do. So I'm going to look into it, but I believe my duty is to be fair to both sides and try to see what's going on. But if it's been dismissed, it is going to stand dismissed. Okay.
I just have one point to add, Your Honor. My sincerest apologies, because I believe at that time, and we mentioned this within the motion to set aside the dismissal, there's a statute of limitations issue. And I believe the dismissal, if I'm not correct, if I'm still correct in remembering the facts accurately, the dismissal did not have anything to do with the actual merits of the underlying case or the merits within the answer. It actually had for the hearing. So it was
I'm sorry. Miss Lee, you kind of you're buffering a little bit. So when you said statute of limitations, after that, I couldn't really understand what you were saying.
Oh, I was just saying that the dismissal was not based on the actual merits of the answer or merits of the actual case. It was based on the plaintiff's inability to appear for a hearing that the dismissal was actually based on. So it was an absence issue and not really an issue based on the merits. But again, if Your Honor, has the opportunity to overlook the documents filed in this case, you'd be able to see that it had more so to do with an absence rather than the merits of the case. And there was a statutory time limitation that the plaintiff was trying to preserve, which is why, I'm appearing now as well. I just want to ensure that, even though I'm no longer this client's attorney, that their rights are preserved as well. And just been, as Your Honor stated, just trying to be as fair as possible so that the case is preserved for whatever they wish to do or their counsel after me wishes to do with this case.
Which, and I think there's like a, I guess, relation back or relate, an ability to relate back to the actual, time of filing. If it was filed within statute of limitations, it is not in a matter that may be resolved in that manner. Okay, so Mr. Lee, Mr. Williams, the two of you can be excused, and I'm gonna look into that issue as well. Your motion to withdraw is going to be granted. I don't
Thank you,
know.
Your Honor. Should I send you that proposed order via email?
I got a notification that they're sending the motion to withdraw to me. So a proposed order by email would be great. The
Okay,
less,
all right, perfect, Your Honor. I'll be sure to do that.
less, yeah, I like to just sign. It's more difficult when I have to prepare stuff.
I completely understand, Your Honor. I will be sure to send that over to you. In fact, I'll send, I'll just re-up and send a forwarded version of the one that I had initially sent on August 3rd. Is that okay, Your Honor?
Yes.
Thank you so much.
And Mr. Lee and Mr. Williams, you both will get word. And I know you're withdrawing from the case, but just to be certain, I just want to make the two of you aware you'll both get word when I look back into this and see where this is, the posture of the case, so that you at least will have word. Okay.
Thank you, Your Honor.
Thanks, Judge.
Okay. So the two of you can be excused.
Thank you.
Position
Thank you
number
so much,
2.
Your Honor.
Thank you. Position 2 is Holmes Custom Collision versus 2012 Chevrolet Tahoe versus Monique Wells.
I am here, sir.
I'm sorry, I did hear a voice, but I didn't know who was
That's
speaking.
me. It has iPhone on it. I have the lock. I'm waving at you.
Okay, iPhone. You are, can you identify yourself, ma'am?
I am Monique Wells.
Okay. Is there anyone here from Holmes Custom and Collision, or anyone, well, Holmes Custom Collision? Anyone present?
Absent, Your Honor.
I'm sorry.
Absent.
Okay. I'm going to come back to that case, ma'am. But if the plaintiff isn't here, that case is going to be dismissed at the end of the calendar. Okay.
Yeah. Okay. May I speak as well?
You can, but you at this point you can only make your situation worse.
No, I just wanted to say it was settled. He paid me my money and it was settled.
Okay. All right. So this case is going to be dismissed for warrant of prosecution. Miss Wells?
Yes, sir. That's it.
You can be excused.
You said dismissed for warrant of prosecution?
Yes.
What does that mean?
So the plaintiff has the burden of production and persuasion.
Okay.
And if the plaintiff does not appear in court, their issue is dismissed.
Hey,
Because-
Judge.
Oh, awesome.
I'm sorry to interrupt. I want to make sure you haven't called my cases. I don't think you have, but the H&A credit cases, I'm here for the plaintiff.
Not yet, Mr. Green. How are
Thank
you
you.
doing today?
All right. Sorry. I got a little scared.
No. I'm moving slowly today. Position 3, Mr. Green, H&A Credit Court versus Lakia Crawford versus Hood Container Corporation as to garnishee. Mr. Green.
Yes, sir.
I just called your case.
Oh, I'm here for plaintiff, Judge.
Okay. Is there anyone present? Is Lakia Crawford present or Hood Container Corporation present?
Absent, Judge.
You said no?
Correct. Absent.
Okay.
Your Honor, this, I believe, is the defendant's garnishment traverse claim. So if they're not here, we'd ask that the claim be dismissed.
Okay. So yes, that motion will be granted. The traverse claim will be dismissed. Mr. Green, can you send me something so I can put my little blue ink pen on?
I can do that, Judge. What email would you like me to send that to?
Send it to Mary.Moultrie at.
I have her email.
Okay. Send it to her and she'll make sure it gets into my hands. Your position 4, Mr. Green. H&A Credit Corp versus Pamela Wright versus Ross Stores Incorporated as the garnishee.
Daniel Green for plaintiff.
Okay. Is there anyone present? Pamela Wright or
Absent,
Ross?
Judge.
I'm Pamela Wright.
Okay. Miss Wright, it is often beneficial to have conversations with the other side to try to resolve your matter. You're totally not required to, but as a judge, it's always better for me that the parties have spoken, and if they don't reach an agreement, that's fine. But it then comes to me. Do you think it would be beneficial for you to have a conversation with Mr. Green?
I don't know.
So do you not want to speak to Mr. Green, or do you want to speak to Mr. Green?
I mean, I can.
Well, I know you can, and I can make that, happen. I'm just trying to ask you a question, ma'am. And it by no means am I trying to make you do anything. But you have not answered a question that I've asked you directly.
Okay.
Could, can, maybe, I will consider. Ma'am, I know you can.
Oh, I mean,
It's,
I don't know what this.
do you want to?
Oh, sure, I do. I want to.
Oh, okay, okay.
Okay.
Well, Mr. Green, I'm gonna make that possible for you and Miss Wright to speak to each other, and maybe you can reach an agreement, maybe you can't. I don't know, but that's gonna come at the end of the call of calendar, man. I'm gonna place you in a room together. It'll just be you and Mr. Green, breakout room, and y'all can talk.
Okay.
Okay. Position number 5, New Image Towing versus Nissan Altima versus, is it
Denman?
Yeah, Janice. Is it Janice Denman Brown?
Yeah, Janice, and Janice is my wife. I'm Denman.
Okay. So
Destiny Chastain here on behalf of New Image Towing, Your Honor.
Okay. So Mr. and Mrs. Brown, do you believe it will be potentially beneficial to speak with the representative from New Image Towing about your dispute before having a court hearing?
That would be our preference. I guess I'm seeking some advice from the court. We sold the car 2.5 years before New Image was ever involved, and we do not know why our names are still associated with the vehicle.
Okay.
Your Honor, can I interject?
Yes.
So typically, if you sell a vehicle and it's not retitled, when we impound it and we send for the VIN to be ran by Clayton County Police Department Records Division, if you are the last known registered owner, your information will come back. And by law, regardless of whether you contact us to let us know you no longer own it, we are required to notify you twice before we move forward with selling the vehicle. So that is what happened in this situation. The vehicle was never re-registered. So it's still under yours and your wife's name. And by law, as a towing agency, we are required to contact you.
So do you understand that, Mr. Brown?
Yes, sir. And we'll be glad to speak with New Image offline and get this resolved.
Yeah, I'll place the two of you in a breakout room, and most likely this is going to be a situation that will be resolved.
Yes, sir.
And so we can deal with that, because they are required by law to follow very strict guidelines when they're trying to go through this whole process. Okay.
Okay, that's fine.
Okay. Position number 6, New Image Towing versus Byron Bullock.
Destiny Chastain on behalf of New Image Towing, Your Honor.
Do we have a Byron Bullock present?
No, Your Honor.
Okay. So as it relates to, I think those are the two. Nope, you got one more case, New Image Towing cases, but it looks like those are going to be easy days for you today, or easy day for you, Ms. Chastain.
Yes, Your Honor.
Position number 7 is Maria McKee versus, is it EDI
Enterprises, Your Honor?
Yes.
Yes, Your Honor. It's Eric Washington.
Okay.
Maria McKee is present, Your Honor.
I told her I'll be back in about 20 minutes because she got to fill out.
Okay. Okay. So, do the two of you believe that it would be beneficial to have a discussion about this matter before having a hearing?
No, Your Honor, I do not believe that would be beneficial, as I have repeatedly tried several months to have a conversation to no avail.
Mr. Washington, do you believe it will be beneficial to have a discussion here today before we have a hearing?
I do not, Your Honor. I agree.
Okay. Now, and I will tell you this, and I always tell people when they're in this posture, somebody's going to leave happy, somebody's going to leave sad. But it's going to be my decision. And if you place it in my lap, my job is to make a decision. It's not to make anyone happy. So if you cannot resolve your dispute, bring it before me. That's my job, and I'll do it. But somebody's going to lose. Position number 8, Bobby Miller versus Defects Region 14.
Yes, sir. Bobby Miller's here.
Okay. Is there anyone here present representing Defects Region 14?
Good afternoon, Judge. Attorney L'Oreal Williams here, appearing specially for the department to object to service because that has not been properly executed, Judge, on this case, and that leaves the court without jurisdiction over the department at this time. Again, I am appearing specially as we got notice of this middle of last week, but no proper service on the case.
Okay.
Can I speak, Your Honor?
Yes, Ms. Miller.
Yes, sir. I've filed several paperwork, so I'm pretty sure they've been notified, because this is what I'm going to court for now, is a default judgment, meaning they had a year to respond to this.
Hold on, Mr. Miller. I need you to understand something. I deal with facts. I don't deal with conjecture. I don't deal with what you feel or what you think. The issue of jurisdiction is the first thing a judge has to always consider, whether that judge has the authority and power to hear the matter that's before the judge. So that has been an issue that has been raised, and that will be an issue that I first consider.
Yes, sir.
And it has nothing to do with the underlying merits of your claim. You understand that?
Yes, sir.
Okay. So this is going to be the first issue I'm going to deal with. Position number 9 is First Franklin Financial versus Christopher Harper versus Four Cs Handyman Contracting. Looks like Ashley Garnishy.
Christopher Harper here, Your Honor.
Okay.
East McKeever for the plaintiff, Your Honor.
You're Mr. Is it McKeever?
Yes, sir.
Okay, you're here with First Financial?
First Franklin, yes, Your Honor.
First Franklin, I'm sorry. Do you believe that it would be beneficial for you and Mr. Harper to have a conversation in the breakout room, try to resolve this dispute before it
Yes, sir.
Okay. Mr. Harper?
Yes, sir.
Are you gonna be willing to meet with Mr. McKeever?
Yeah. Yes, sir.
Okay. So I'm gonna place you all and you're gonna be in breakout room 3.
Excuse
Position.
me, Your Honor. Is
I'm
Miller
sorry.
dismissed right? Is Miller dismissed right now?
No.
Okay. I'll just make sure. Thank you, sir.
You're welcome. Position 10, New Image Towing versus Nissan Sentra small car.
Destiny Chastain on behalf of New Image Towing, Your Honor.
And I'm presuming you're going to present me with an order.
Yes, Your Honor. For this one and the first one you called against Mr. Bullock.
Yes. And let's see. All right. That appears to complete the call of my calendar. Is anyone here that expected the name to be called and the name wasn't called? Okay. I'm going to place Mr. Green and Ms. Wright. You're going to be in breakout room number 1. I haven't set rooms up yet, so give me a moment. New Image Towing and Mr. and Mrs. Brown, you're going to be in breakout room number 2. And I would presume that your conversation is going to be very short because you don't own the car anymore. And I still have to go through the steps of you both have spoken and agreed. This is what the lay of the land is. So I'm gonna give you that opportunity. Position number 6 looks like that's going to be resolved because the Mr. Bullock is not here. Ms. McKee and Mr. Washington. Yes, I'm sorry. Yes, Mr. Hutchinson. Answer your question is yes.
Thank you, Judge.
You're welcome. Ms. McKee and Mr. Washington.
Yes, Your Honor.
You both said that there's no reason for you to speak, correct?
Yes, Your Honor.
Okay. That's going to be the second hearing. First Franklin and Mr. Harper, I'm going to place you all in breakout room number 3. And then position 10 with New Image Towing and the Nissan Sentra, that's going to be a issue where I'm going to get in order. All right, so give me a moment. As I said before, I went to law school, didn't go to Georgia State, so this is where we get to the shaky part of what I can do.
Judge, may I ask a question?
Yes, sir.
In the event getting these things routed to the breakout rooms is not successful, would it be agreeable with New Image Towing if I just called them on the telephone if we were to lose a connection?
It would be they I just want you all to speak, and if you're in agreement, they will send me over the paperwork from my signature.
Okay.
Because from the announcement that was given, it just appears as though you're here simply because the information it has is the ownership of the vehicle was not updated and wasn't changed. But I do not want to make assumptions. I want to make certain that you know, people can have their day in court.
Okay.
So I am placing New Image Towing and Mr. and Mrs. Brown in breakout room number 1. I'm going to place New Image Towing and Denman Brown. No, sorry. Where did I go wrong? Sorry. I should have, well, Mr. Green and Miss Wright, you're going to be in breakout room number 1. No, I'm sorry. Again, we're looking at this screen and your eyes are getting to the point where you're
I don't
trying to
have
figure
the
stuff out.
invitation yet, Judge.
No. It hasn't been sent out. Mr. Green, you and Miss Wright are going to be in breakout room 2. I'm having Mr. and Mrs. Brown, New Image Towing, you're going to be in breakout room 1. And Mr. Harper, and Mr. McKeever, I'm sorry. I'm going to be in breakout room number 3. Mr. Harper, are you showing up as iPhone?
Say again, sir?
Are you showing up as iPhone? Yes.
Yeah, I got an iPhone.
Okay. Well, yeah, you're showing up as iPhone, and it just becomes important when I'm trying to assign people to a room. Let's say, okay, so you all should have received links to show up in the rooms. The first thing I'm going to deal with is position number 8, Bobby Miller versus DFAX region number 14. And Mr. Washington, I'm going to get to you, and Ms. Miller, I'm going to get to you. I'm sorry, Ms. Washington and Miss Marie. McKee, I'm sorry. We had Judge having emergency medical issues, and so I've been doing double duty today. So I've been going back and forth. So for the record, this is position number 8, case number 2021 CM 11264, Bobby Miller versus DFAX region 14. And Ms. Williams is here representing DFAX, and Mr. Miller is here on his own behalf. Ms. Williams, you have indicated that there's a jurisdictional issue as it relates to this case. So could you please enlighten me on that?
Thank you, Judge. And again, I state to the court that I am appearing specially on behalf of the department. The issues that lie before the court as it relates to jurisdiction, there has not been proper service pursuant to OCGA 49-215. And under that code, Judge, the plaintiff should have served the department through its commissioner. And
that's in Fulton County, correct?
That's correct, Judge.
Okay.
At 2 Peachtree. So that should have been the proper service. We did not have that. What I do have, there was something delivered to the Clayton County office back in July of 2021. However, this is just coming to my attention and the state's office attention as of last week. And the person that is listed as served, I'm not familiar with that person, although I am familiar with the individuals at that office. But again, it should have been on the commissioner to perfect service under 49-215. So we would object to anything going forward today until that happens.
Your response, Mr. Miller?
Yes, sir. That's the exact address that I put on my paperwork because that's where the checks come from in Atlanta, which is DFAX Regional 14. The address is in Atlanta, and that's where I filed my paperwork. And I filed this over a year, almost a year and a half ago. And now I'm at a judgment default.
Okay, so the objection that was stated was for lack of proper service. How was service perfected?
Through the courthouse, through the civil court, they said they were served at the address of, I'm pulling it up right now. What did they say? Okay, they were served on, let's say, service was served on 7/13/2021.
To whom?
The DFAX Region 14 located in Atlanta, Georgia, not Clayton County. The same address that appears on their check that I get every month now. And the address is, let me see, can I find the address on this paper here? It says 2 Peachtree Street, Northwest, Atlanta, Georgia, 30303.
You have a return of service?
Do I have a return of service? No, sir. They didn't send me no paperwork on that. That's just the address that I put on my paperwork to have it served to. I didn't get no receipt of when it was served. It just said the date of that the day it was served on.
And Judge, if I may interject, I do have in front of me a copy of the statement of claim that's signed by Mr. Bobby Miller. The court should have this. Looks like it was filed on July 6, 2021. And even in the heading here, it lists Mr. Bobby Miller and his address in Jonesboro, Georgia. It lists DFAX Region 14 at 485 Atlanta South Parkway, Atlanta, Georgia, Suite 335. Again, I'm not familiar with that address, and I haven't checked that because I don't represent the people at that office. However, the commissioner is not at that location. That is not where service is perfected. And I have nothing to show that that actually occurred. And my client is telling me, upon being asked multiple times, they have nothing to show that they've been served through the commissioner as required by the code.
Mr. Miller?
Okay. So I'm just here doing a regular Google on DFAX Regional 14, and it's actually pulling up the same address, 2 Peachtree Street. So why would the title be at DFAX Regional 14, but have a different address on the paperwork?
Judge, we ask you to take judicial notice of that statement of claim document. And again, the court should have that filed on July 6th.
I'm pulling it up now. So, Mr. Miller.
Yes, sir.
It's never a good argument in court to ask the question, why? Because you're supposed to be presenting an argument. And if you're presenting an argument, you shouldn't have to say why. You should be asserting a fact.
Okay, so my fact is it was filed for DFCS Regional 14. And that's what I put on my paperwork. That's Regional 14, which is located at 2 Peachtree Street.
Mr. Green, do you have a resolution or this is going to be a hearing?
Your Honor, there's no resolution, but the defendant doesn't work at the garnishee anymore. So, I mean, I think we could just deny this as moot.
Okay. Ms. Wright, do you have any objections to that?
I don't know what that is.
So it appears that they are attempting to garnish wages from Ross stores, and you don't work at Ross stores anymore, so they can't garnish any wages that you may have earned or will earn at that location. So Mr. Green is essentially asking me to dismiss the claim.
Okay, I understand that.
So my question is, are you going to object to his request for a dismissal?
No, I'm not. No.
Okay. Mr. Green, would you mind
Yes, Judge.
sending me a document I can put my signature to close
Sure,
this
Judge.
matter?
Yes, Your Honor, I will do.
Okay. And your other case,
I was going to send that one as a dismissal since the defendant didn't show up.
right. So if you would do those two things for me, you can be relieved of your obligation to be here today.
Thank you so much, Judge. Take care.
Have a good day. Miss Wright, you can be
Thank you,
excused
Judge.
also, ma'am.
Yes.
Okay.
Okay, thank you.
You're welcome. Ms. MacGyver, and for Ms. Williams and Mr. Miller, I'm pulling up these documents now, but trying to do as much as I can while I can. Mr. MacGyver. I'm sorry. I keep calling you MacGyver.
Yes.
Mr. McKeever.
Yes, sir.
Do you have an announcement?
Well, I don't see where Mr. Harper came back.
I'm back. I'm back.
You back? Okay. Yeah, we came to an agreement. We're gonna set aside our default, and his company is gonna start sending in answers to the court.
You're gonna set aside your default and
our default request.
Uh-huh.
We're gonna set aside our default request. Yeah, I don't think it has been granted yet, Your Honor.
Okay. Give me a second. Give me a second. So is this something where you have all reached an agreement as to how this matter is going to be dealt with, or is you just saying we'll just come back another day?
No, Your Honor, we reached an agreement how it will be dealt with.
Okay. So what I'm going to request is that whatever agreement that you have reached, that agreement gets memorialized in writing and sent back to me, and I'll sign off on it, and everybody gets to move on with their life.
All right.
Okay, Your Honor.
And well, I'm going to ask you to send it to Mary.Moultrie, MOULTRIE at ClaytonCountyGA.gov.
I'll put it in the chat for everybody.
Okay, thank you, Ms. Mary. And she is my backbone. She makes sure that I do what I'm supposed to do. So you send it to her. I'm gonna get it in my hand.
Okay, Your Honor.
We'll be able to memorialize this agreement, move on, and everybody can be happy. Okay.
Okay, Your Honor.
Okay.
All right.
Hey, Your Honor, can I get Mr. Harper my phone number?
Sure.
Let me know when you're ready, Mr. Harper.
Hold on for 1 second. Hold on for 1 second. What I did with it.
Before you give your number out, sir, remember we're on YouTube. Do you want everybody to have your telephone number?
That's fine.
Okay.
Oh, Miss Mary, he's a handsome guy. He probably gonna get a bunch of phone calls.
Okay, well, and we don't want him to call the courthouse talking about all these women are calling in. I'm trying to help him out.
Sir, I don't have a pen right now. I'm looking for it. There any way you can just send it to me in an email?
I can try. I can't make no promises. Actually, if
you don't have my number on file.
I do not have your number on file, but I can look and see if it's the correct number.
It'll be the correct number.
Can you call the First Franklin as you spoke to her before, and then they'll transfer you to me.
Say again now.
Call the First Franklin you spoke to before, and they will transfer you to me.
Okay, I got you.
Okay. Thank you, Mr. McKeever and Mr. Washington. I got your name right on the last go round.
Yes, sir.
All right. I'm going to remove you two. Have a good day.
All right. Thank you, Your Honor.
But send that information in so we can get it signed, sealed, delivered, and taken care of. Okay?
I will, Your Honor.
Okay.
Thank you.
Mr. Brown.
Yes, sir.
Mr. and Mrs. Brown. I'm sorry. I didn't mean to exclude you.
That's fine.
Mrs. Brown. And New Image. Did you guys reach a resolution?
Yes, sir.
Yes, sir, we did. I think we have a better understanding. And we came to the conclusion that I'll submit the order to Ms. Moultrie for your signature, Your Honor.
Thank you. And that concludes New Image business here today. So you can be removed. And Mr. and Mrs. Brown, it was great meeting you. You all have a good day.
Thank you, sir.
Okay. Goodbye.
Thank you, Your Honor.
I'm gonna remove you both.
Thank you.
Okay.
Your Honor, this is Mr. Miller. Can I say something?
Well, first, let me say something.
Yes, sir.
I pulled up the service, and the address is 485 Atlanta South Parkway, Atlanta, Georgia 30349.
Yes, sir. That's exactly what I was just looking at myself here, because I'm trying to see the indiscrepancies of this is where the mail that they send me comes to me. So I'm trying to see how to come up to 2 Peachtree Street when this is where my checks come from.
I'm looking at the service, and that's the issue that Miss Williams brought up.
Yes, sir, I understand now. Yeah,
not where checks are sent to or come from. Service.
Yes, sir, I understand.
So it appears as though Miss Williams is correct.
Yes, sir.
That there's been a lack of service.
Yes, sir. I totally agree on that, because I see exactly that it's not coming to her office, it's going to this other office.
Well, so the whole system as it works, as you can see, Miss Williams is, you see, SAD, that's Special Assistant Attorney General. And throughout the DFACS system, there are attorneys that work in varying counties because Georgia has 159 counties. So you have to serve the main office, which is Peachtree Street.
Yes, sir.
And without serving the main office, you haven't provided proper service. So this matter will be dismissed without prejudice for improper service. Is there any concerns, Ms. Williams, as to?
No concerns, just a question. Does the court need a proposed order for that finding?
Yes, please, if you can, send it to Miss Mary.
I wrote her email address down.
Okay. And that will allow this to be, as they would say, signed, sealed, and delivered. Yes, yes.
So I can't refile on this new finding I just found out?
When you say new finding, what does that mean?
That I have to go through the different address, redo the whole process and go to this address here because it's still a problem. I think this is like a federal problem, to be honest, because you're placing kids in people's homes.
Well,
federal funding and ain't nobody getting compensated for it.
Mr. Miller.
Yes, sir.
I have several thoughts that are not law. And just because you think something doesn't mean it's the law. You have the ability to refile.
Oh, yes, that's all I need to know.
Yeah,
yes,
as
sir.
long as you're within, as long as you're within the statute of limitations, you have the ability to refile. There may be certain things as it the doctrine is called relating back, but all of that stuff is something that is probably best placed in the hands of a lawyer. But I'm not making any judgment that you can or cannot.
Yes, sir.
Because that would be giving you legal advice, and I can't do that.
Yes, sir.
Okay. All right. Any other questions, Mr. Miller?
No, sir.
Ms. Williams, are you gonna send me that information?
I sure will, Judge.
It was a pleasure to meet both of you. I hope the two of you have a good day.
You as well, Judge. Thank you.
Right. Thank you, sir.
Thank you. Thank you. All right. Okay. I'm gonna remove you, Mr. Miller. All right. Mr. Washington and Miss McKee.
Yes, Your Honor.
What are we gonna be dealing with here today? For the record, this is case number 2021 CM 03190, Maria McKee versus Mr. Eric Washington. And it's cut off on my calendar, but it's Washington. It says DBA. Is it EDI?
Yes, Your Honor. EDI Enterprises.
Enterprise. Okay. So, Miss McKee, as plaintiff, you have the burden of production and persuasion. Tell me why Mr. Washington is indebted to you.
Yes, Your Honor. Back in July of 2020, myself and my husband hired Mr. Eric Washington, DBA EDI Enterprises, to do a bathroom remodel job at our home. The scope of that work was to do a new shower, so demo the old shower, do a new shower, a new tub facing, tile the floor, and paint and put up a light fixture. And that started early in July of 2020. He gave us a total price of $6,000, in which my husband made an initial payment of $4,000.
I'm sorry. I'm stop this for 1 second, okay? I'm doing double duty today. I'm sorry.
Okay.
I'm sorry. It's I'm doing three different jobs today. So
okay. So you know where I left off, Your Honor?
That there was a contract or an agreement that there was going to be work done in your bathroom.
Correct. Yes. So, and that was in July of 2020. We paid him the initial cost that he quoted us was $6,000. My husband paid an initial payment of $4,000 to get the work started. And I do have the receipt for that because it was paid to his QuickBooks account.
And it was materials and stuff like that to get.
Exactly. I'm sure he used that to, do the startup on the project.
Okay.
The remainder of the funds, $2,000, was paid to him in cash. I failed to also tell you that we hired him due to a referral from a coworker of mine. He did start on that work project in July, and he completed some of it, in which he completed the tile floor. He did the demo on the shower. He painted, and he installed a light fixture. He actually started on the shower, but he got to a point to where he never completed the shower. He never completed the baseboards in the bathroom. He never completed totally finishing out the facing of the bathtub. And I just think it was that he got to a point with the shower to where he didn't know how to finish it. So what I had to do was, I mean, we made several attempts to contact him, and I have some of the text messages and emails that we sent him beginning in July. He was responding, but when we got around to September, according to him, I believe he was in an auto accident, which we understood, and we understand if you're in an accident, you hurt, you gotta get well. I even sent him text messages saying, I understand you were in an accident, but would you please just communicate with us, because we got a shower that we haven't had use of for several months now. Around October, that was in September, but somewhere around October, to my recollection, he just stopped responding totally. So in December, I sent him like one last text message, and I told him that it was obvious that he wasn't going to complete the work. So I was asking him to refund me. In my text message, I believe I just asked him, if you just refund me $2,000 or the $6,000 so I can try to get somebody else to finish up this work, but to no avail. So I have not heard from him since October of 2020. So 2021, February, I filed for a statement of claim. Since that time, Your Honor, I did have to hire someone else to try to come in and fix it, but it is just a total mess. I have pictures of how he left it. It's still incomplete. I still do not have use of my shower area in my bathroom, and that's what brings me here today to ask for a judgment in the case.
Mr. Washington?
Yes, Your Honor. Well, first of all, I'm not contesting that I did not finish the job. I understand I didn't finish the job. And as Ms. McKee stated, I let them know that I was in a car accident. My truck was completely totaled. So at that time, I understand it's not their problem. And I understand that it is my job to finish what I start. But at the time, I was mentally not there to do it.
What does that mean?
It means after losing my truck, I basically lost my business because my truck runs my house. I didn't have reliable transportation. So I basically was becoming depressed. And instead of reaching out like I should as a business owner, I just kind of closed myself in.
I understand. So you're not contesting her claim?
No, I'm not contesting her claim. What I am contesting is the amount. Because $6,000 was almost 98% of what the job was worth. And 4,000 of that was for materials. The only thing that I recollect that was not complete was the shower. The floor was complete, the bathtub was complete up until they asked me to tile the front of the bathtub, which came after. I initially did not go in there thinking I would have to tile the front of the bathtub, but we came to an agreement and I started to tile that as well. Now, as far as the shower is concerned, I put the stone in the shower, but I couldn't finish the doors because I couldn't physically do it by myself. Everything else I could do by myself. But as I stated, I didn't have transportation and I was still in pain from the accident.
So let me ask you this question, Mr. Washington.
Yes, Your Honor.
Ms. McKee seems to be very reasonable, and you seem to be very reasonable. How can you, given where you are now, with physical limitations or whatever, how can you make this situation right?
I
And that
mean,
it doesn't fall at the feet of Miss McKee and her husband.
well, if she still has a shower door, she stated the project is not complete. And I'm in a position now, if she will allow me to, I'll go in there and complete the job.
I would suspect if I was in Miss McKee's position, I would want some kind of guarantee. Meaning, like, it's not that you're just making a promise to me, because they accepted your word when this whole thing started, based upon what I've heard. And they have a right to, at this point, not feel as though you can follow through.
I understand that, Your Honor. If they want me to. Sorry, my daughter came in from school.
No. That's my son just came in too. I understand. So this is the point that I'm getting at, is that stuff happens in life, and Miss McKee seems to me to be a reasonable person.
She is.
But they paid you money. Her and her husband paid you money to have a job completed, and they have every right to expect that that job is going to be completed and finished. And Miss McKee has as Civil World works, I can issue a money judgment today, but then you're going to have to go and try to collect on that money judgment. And that's a whole separate ball of wax. I do not try to push any idea on anyone. I try to have people meet in the middle and resolve their problems so that they can go about their life. Ms. Washington, I can't, based upon what Ms. McKee has introduced today, I can't say that she or her husband is in a position where they can reasonably believe that if you reach some kind of agreement today, that it'll be resolved. Miss McKee, I can give you a judgment today. That doesn't mean you're gonna get the money. You have a piece of paper that says he owes you and your husband money. So I'm not a person that just believe that the law, you can just look at the law, open up the law book, and that's going to solve everything. And I try to give people agency over their lives so that they can do whatever they need to do. Mr. Washington, if Miss McKee and her husband were willing to give you an opportunity to finish what you said you were going to do you believe you can do it?
Yes, Your Honor.
And Miss McKee, my understanding is what you paid $4,000.
Well, we paid him a total of $6,000, Your Honor, but I paid an additional $4,000 since that time to try to get a working, usable bathroom.
For the remediation and trying to get it so that you can actually use it.
Yes, Your Honor. And I'm still working with that. And to be honest, I just don't think that he has the ability to do what we thought he did and what we asked for. And about the shower glass, you're absolutely right, Mr. Washington. That shower glass is standing in my hallway now, waiting on me to get a dumpster to throw it in, because I had to buy custom glass. And when I called a custom glass company out and they measured my shower, they said it was no way that that shower glass that we purchased through Mr. Washington was going to work in that shower. So I just don't, that's just not gonna work. And I do understand, Your Honor, about the judgments and, getting 5 phase and what have you, but, I would be willing, I asked for $6,000 in the statement of claim, but he did do some work, and I don't deny that he didn't do some work. That's why way back in December 2020, I just said, give me $2,000 back of the $6,000 and I'll be done. And to no avail. So I would be willing to work with him on that. But if he's not gonna pay me, then I'll just take the judge. I would ask for a judgment, Your Honor, and I'll just get a 5A, and I'll just keep redoing it. So
I do understand, and that's the thing where it's like I don't view anybody that appeared before me as being bad or good, because we're all human beings and we all deal with that. But I know I'm not gonna place anyone in a position where they are now subject to something that they should not be subjected to. I mean, I'm still, I'm gonna give you guys a little bit of information, too much information, TMI. And I'm 2 weeks into waiting to get my car back from the repair shop. I was supposed to get the car back last week. And I had the conversation with the people like, hey, how about, y'all look at the car, y'all figure it out. I'll drive the car away. You go get the parts, and then I'll bring the car back. And you can put the part. No, we don't do that. They get in. I was supposed to get the car back a week ago, and they're like, "Well, we found this thing, and we ordered the part, but the part ain't got here. We waiting on the car part." And I'm like, people shouldn't be treated that way. And so, Mr. Washington, I do appreciate the fact that you have acknowledged, kind of what happened and what's going on. But Miss McKee and her husband are entitled to be made whole. And that would include what they had to do to get somebody else to come in and
I understand, Your Honor.
and repair, not repair, but finish the whole thing. But because I don't view anybody as being inherently evil, and I view people as we're all subject to the human condition, I think it's better for everybody to get along than to have those problems. But that's not an obligation on any litigant, whether they're plaintiff or defendant. So what amount of money are you asking for, Ms. McKee?
$6,100.
And that's based upon the $4,000 plus the monies that you and your husband had to put in to finish the job.
No, that's actually just what we paid for the whole job to Mr. Washington, Your Honor. That's not including the additional costs that I've incurred since.
Okay. Ms. Washington, are you challenging the final amount that she's asking for?
Your Honor, I am challenging it, but I understand that she didn't include what she's already spent on top of the $6,000 she paid for the original job. So I mean, at this point, I can just try to pay her back. That's all I can say.
That's an honorable thing to do. So tell me the amount one more time, Ms. McKee.
$6,100.
$6,100. Okay, so that'll be the judgment of the court for $6,100 to Ms. McKee and her husband. I would encourage you, Mr. Washington, you seem like a lovely person. I'm an old gruffy guy, even though I don't look like it. And I, you know, life comes at you fast, and it's over way too quick for most of us. And what you do and how you treat people is a legacy that you will leave for years. And, you know, I have not experienced you, Mr. Washington, as a bad or evil person. And believe me, I see a whole lot of stuff sitting as judge. And I think that you know, you can move on from this and you pay your debts and you'll be a happy person. Miss McKee, I haven't met your husband, but I've met you. You've been a perfectly lovely lady. And your husband is obviously a lucky man. I don't know what he did to get you, but he's a lucky man.
Thank you, Judge.
And so I just always, I wish everyone well, because, you know, we all have seen too much bad stuff in our lives, and I don't want to see another bad thing. And to support people and help people and move them along that path, if I can do it, if I can help you, I'm going to help you. You can call Judge Gardner, and if I can help you, I'm going to help you. And it's to me, it's a wonderful thing. So my wife says I talk too much. But I'm like, I went to law school. They taught me how to talk. What am I supposed to do? All right. Ms. Washington, do you have any questions?
No, I don't, Your Honor.
Ms. McKee, do you have any questions?
Yes, Your Honor. What would be my next step? How do I get the judgment and where do I go from here?
Well, it'll be entered within the next 10 days.
Okay.
But then the whole thing of how to collect on the judgment, that's the big part. You're gonna get a piece of paper, But how you turn that piece of paper into cash becomes a whole nother different thing. And Mr. Washington, I would encourage you, you know that this order has been entered. You can enter into an agreement with Miss McKee and her husband and say, look, I can pay you $100 a month. I can just, until this is paid off, I'm gonna pay you this amount of money. And that stops all kind of other stuff that may be going on. And it becomes a bill, but you can reach into an agreement about payments where it's paid off and they have their money. You can pay it off in a manner that's where you can deal with it, and then everything goes away.
And how do I show proof of that?
When you say show proof,
like let's say later on down the line they say it wasn't good enough or they want all their money and we already have an arrangement. I'm not saying that they would. I'm just saying just to cover myself. How do I?
No. It should be a written agreement.
Okay.
Between the two of you, where you agree to do X on X amount of money by X day every month, and then they're paid off.
Okay.
And it's because it's, you know, I tell people my you know, my wife and I, when we got married, and she lost her job maybe 2 months after we got married. And I knew to the penny every amount of money we had in the bank account. And I knew what I could spend and what I couldn't spend. And
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.